Morning.
My please, Lordship. I would like to mention item 27 on behalf of MS Ranu Bora. She is the standing counsel of
27.
27.
It's an order matter.
She has requested
This
that.
court will accommodate. Just let one of your junior be there.
Yes.
We'll see why the matter is posted for orders. Please do
All
not
right.
make mention of order matters. We shall accommodate everyone, but let us see why the matters are posted
Okay.
for orders. Yes, call the list. Any more mention?
Yes, my lordship. I beg to mention item number 15, my lordship.
Yes.
This matter may be listed after 3 weeks. My lordship.
15.
Yes, my lord.
You are for?
Respondent.
Have
Government.
you taken consent from the other side?
Yes, ma'am.
MS so-and-so, learned counsel for the respondent number?
All the respondents.
Or for the respondent, with consent from the other side, 6 for
3 weeks time.
3 weeks time. Prayer allowed, list after 3 weeks on a date to be fixed by the registry. Next.
My lordship, I beg to mention item number 11.
Yes.
I am on behalf of standing counsel, Mr. N. Pada. Yes,
Affidavit in opposition was to be filed.
yeah,
When will
lordship.
you file?
After 3 weeks.
As prayed for by Mr.
Yeah, Apum.
Your name. You
Yeah.
don't know your name?
Jordan Apum.
So-and-so, learned counsel for the respondent. List this matter after 2 weeks to enable the respondent to file their affidavit in opposition in the matter. Stop. You have informed the petitioner?
Lordship, I beg to mention item number 16, 17, 18 with the consent from other side on behalf of,
Have you served extra copies?
no, I am for the state. Yeah,
What
we
do you
received,
want? You have received?
yes,
So you want time for?
filing contract.
Have you informed the
Yes, I
petitioner?
will.
As prayed for by Mr.
ROU.
So-and-so, learned counsel for the respondent.
All the respondents.
For all the respondents with the consent from the petitioner, list this matter after 3 weeks to enable the respondent to file their returns in the matter. 16, 17 and 18.
Your Lordship, I beg to mention item number 12.
12.
Due to medical condition, the concerned counsel is out of station.
You are for?
Petitioner.
Petitioner.
Yes, consent has already been taken.
It is informed that the arguing counsel, Mr.
Tayo,
So-and-so is unwell today. Stop. Accordingly, accommodation is sought. Prayer not opposed. List this matter after
3 weeks.
3 weeks on a date to be fixed by the registry. Yes.
Your Lordship, I would like to mention item number 14 on behalf of Mr. Subbu Koyang,
You are
petitioner.
for respondent.
Yes, no, not petitioner. Subbu
You
Koyang.
served extra copies.
Sorry,
Extra copies were required in this matter to be served. Have you done it or not?
actually,
don't know.
I am actually not leading counsel of this matter.
Why
I am
do you-
just conveying this other, but he is
Why do you
unable
want
to
time?
mention this matter.
Why do you
Please.
want time?
Sorry,
Why do you want time?
3 weeks, after 3 weeks.
Why?
Imagine actually, my lord, he is the out of station for urgent ground. Actually, I am not the leading counsel of this matter.
That Mr. So-and-so, learned counsel for the petitioner.
Petitioner.
is out of station.
Out of station.
Accordingly, accommodation is sought. List this matter after 2 weeks on a date to be fixed.
3
by the
weeks.
registry.
3 weeks.
Make it 3 weeks. Item number, what was the item?
14. All right.
Next.
May I please, Lordship? Lordship, I beg to mention item number 9 on behalf of K. Lolan.
You are
Here,
for?
respondent, Lordship. Here, some more time is needed as both the parties are at the verge of settlement, Lordship.
Have you taken consent from?
Yes,
the-
yes, already taken.
MS so-and-so, learned counsel for the respondent submits that there is that the parties are exploring out-of-court settlement in this matter and accordingly seeks some time in order to explore the same. Stop. Prayer is allowed. List this matter after 3 weeks on a date to be fixed by the registry.
Lordship, I have one more item to mention. Item number 40 on behalf of K.
It
Lolan.
is already mentioned.
Oh, okay. 40.
All 40.
40.
Yes.
Your lordship, the conducting council is out of station due to some urgency, lordship.
It is submitted that Mr.
RC Lawangcha.
So and so learned counsel, learned arguing counsel is out of station and accordingly some time has been sought. Prayer allowed, list after 2 weeks on a date to be fixed by the registrar.
Lordship, 3 weeks.
Next. Make it 3.
May it please, Your Lordship. Your Lordship, I beg to mention item number 38, Your Lordship. 38. Your Honor,
Fire quashing.
yes, Your Lordship. I'm for the private respondent. Your Lordship, I have taken consent from other side as well.
Mr. So and so learned counsel for the respondent number.
Private
For
respondent.
the private respondent with consent from the other side, 6 to
Yes, Your Honor, this
2
matter.
weeks time.
No, Your Honor, I want Your Honor specific that because the petitioner
6 accommodation in the matter, list this matter on
8 May.
8/5/2024.
Yes, Your Honor. Deeply obliged.
Lordship, I would like to mention item number 8. I am for the petitioner. I have
Item number?
8.
Yes.
I have taken consent from the respondent. So this matter may be fixed on 28th of May, Lordship.
Have you informed the other side?
The other
I
side is
Mr.
V. Jammu.
B. Jamo learned counsel for the petitioner with consent from the other side seeks accommodation in the matter. List prayer allowed. List this matter after.
All on 28th of May.
List this matter on 28th May.
Yes.
2024.
Lordship, there is an interim that may continue.
Interim, if any, shall continue till the next day.
Deeply obliged.
Where is the petitioner? None appears for the petitioner when the matter is called. Yes?
My
Cancel
lord,
the order.
my lord, this number 1, item number 1 may pass over because of the document issue.
Hmm?
Because of the document issue.
Passover for what?
Because of the missing of document issue. My main concern is,
Passover for the day or Passover
no, not day,
for the time being?
for timing.
You want this matter to be called after some time?
Yes.
Call up. NDPS notice,
Yes, Your Lordship.
call for CD notice, list this matter on. Yes,
Your Lordship, on 6th, Your Lordship.
6
6th of
May.
May, yes, Your Lordship.
5/2024. You are APP?
Yes, Your Lordship. Deeply obliged.
Three,
Yes, may I please, my lord?
353, 171.
My lord. My lord, yeah, in a similar matter, my lord, who accused has been granted some interim no, and directed to,
Interim.
yes, my lord, and
Where?
that, my lord, here is the order, my lord. During the file, at the time of filing, my lord, this order was available.
Where is the FIR?
My lord, the FIR is at page 9, man. Starts from page 9, man.
Yes. Who are you?
My lord, I am an agent, polling agent of,
You are a
Indian-
polling agent.
yes, ma'am.
Yes, APP.
Yes, Your
Let
Lordship.
them appear. In the meantime, let them appear and
Yes, Your Lordship. And the matter was fixed on 14/5/24. All the matter may be come up together, Your Lordship. Together.
heard Mr.
Peace, okay, ma'am.
So and so learned counsel for the petitioner also heard Mr.
Theater.
T.
ETE, Your Lordship.
T so and so learned APP for the state respondent. This is an application under section 438 of CRPC for granting anticipatory bail to the accused petitioner, i.e. Tajum Nalo, who is apprehending arrest in connection with Talbia PS case number 4 of 2024 registered under section 353-171C 34 IPC read with section 136 RPA. Stop. Call for the case diary fixing on 14/5/2024.
Yes, sir.
Stop. Considering the facts and circumstances, comma, it is provided that in the event of arrest, the petitioner named above shall be released on interim pre-arrest bail in connection with above noted case on furnishing bail bond of rupees 30,000 only with one surety of like amount to the satisfaction of the arresting authority subject to the following conditions. 1, 2, 3. Appear within 5 days.
Yes, Your Lordship.
List accordingly.
Oblige, Your Lordship.
My lord, I
4 is
can,
also same.
yes, my, but it is different case number, FIR number 5, my lord. Otherwise similar order have been passed, my lord.
Here the petitioner's name is Burik Tariq Rai
My lord.
and who is apprehending arrest in connection with Talia PS case number 5 of 2024 registered under section 353-171C 34 IPC read with section 136 RPA. Okay. Yeah. All right.
Oblige, Your Lordship.
Yes.
Notice was issued way back on 18/12/2019.
Some
Yes.
affidavit in opposition is
Yes,
to
the
be filed.
Union of India.
Yes.
Yes, Your Lordship, we have filed, Your Lordship.
Who is to file?
Union of India.
Where is union? Yes, what happened to the affidavit?
Like it's, like, I don't file.
Fine. I don't find.
You are Mr. Ratan.
Malad, I'm
No, Mr.
M. Katma. Malad, in fact, this case was handled by Malad Ali council. So, Malad, in fact, we are not in a position to Malad get the instructions. So, it is says
No,
that
this is now going to appear in this matter for the union. So you speak for some time.
Yes.
In the meantime, you file the returns.
I'll take instruction.
M. Kato.
Malad,
Mr. M. Kato Learned,
DSGM,
DSG
I.
I submits that he has been newly handed over, that the file of the case has been newly handed over to him and accordingly seeks time to obtain the instruction in the matter and file necessary returns thereof.
Malad.
Stop. Prayer is not opposed. List this matter after 3 weeks on a date to be fixed by the registry.
Malad, one more thing, my name may be reflected in the court.
The name of Mr. M. Kato Learned DSGI be reflected in the cause list.
Malad. Oh, different.
Affidavit has been filed.
Yes, my lord.
You filed the affidavit in reply.
Yes, my lord.
Who is appearing for the respondent?
Your Lordship, the leading counsel is at court number 21.
We fix another date.
Yes, lordship. Another date maybe for the supplementary hearing. Pleading is complete, Your Honor.
Pleadings is complete.
Yes, Your Honor.
Then I'll admit it and post it for hearing. Heard,
And there is
Mr.
interim order is there.
Heard, Mr.
A Bodo.
A. Bodo, Learned Counsel for the petitioner. Stop. Also heard, Mr.
El Tadam on behalf of the
Learned
complaint.
Counsel for the respondent. Stop. Petitioner has prima facie made out a case for hearing. List this matter. Admit. List this matter for hearing on.
After 4 weeks.
List this matter for hearing on it after 4 weeks on a date to be fixed by the registry.
There is interim protection is there.
Interim, if any, shall continue till then.
Highly obliged.
Yes, affidavit in opposition, Land Management Department,
My lord, matter may pass for a moment.
Land Management Department.
Standing counsel.
Your
Where
Lordship,
is
your
the
standing counsel,
file?
your Lordship, I have no idea. The standing counsel is
How
at
much
court number
time
1.
is to file the affidavit?
Uh,
2 weeks?
okay, 2 weeks maybe.
You want something else?
My lord, senior counsel is,
What
Won't
this matter, the affidavit in opposition is yet to be filed,
okay.
so let them file it. Mr. So-and-so, Learned Counsel for the Land Management Department seeks 3 weeks time to file the affidavit in opposition in the matter. prayer not opposed, list this matter after 3 weeks on a date to be fixed by the registry. File it within 3 weeks.
Yes.
But on the last day, your lordship had,
Indian succession. You have filed your written arguments.
yes, my
Yes,
lord,
sir,
list of this.
Indian succession. The letters of administration is applied under the provisions of the Indian Succession Act.
Yes, ma'am.
Okay, I will pass the order now. I've already heard both of you. Heard Mr.
D. Soki, ma'am.
T.
D.
D. Soki,
So-
learned counsel for the petitioner. Stop. Also heard Mr.
V. Jamo.
P. Jamo, learned counsel for the respondent.
Respondent.
Mr. Soki, please flag the provisions for LA. The petition has been filed under section 115, read with section 151 of the Code of Civil Procedure and article 227 of the Constitution of India, seeking quashing of the ex parte order dated 9/10/2023, passed in IA number 2 of 2023, arising out of the LA case number 6 of 2023, pending in the Court of District Judge LO, West Siang District, Arunachal Pradesh. Stop. The facts of the case are as follows. On 15/12/2021, the father of the petitioner passed away. Thereafter, upon a complaint lodged before the village authority by the petitioner, a keba was held on 16/7/2023 by the head Gaon Bura, whereby the disputed property was divided between the petitioner and the respondent.
My lord.
Stop. Pursuant to the aforesaid division, the respondent filed LA case before the district judge Alo on 26/7/2023, which has been registered and numbered as LA case number 6 of 2023. Stop. In the meantime, since the petitioner was unable to collect rent from the partition portion of the property, he filed a complaint before the village authority on 13/8/2023. Stop. Pursuant to the aforesaid complaint, within quotes, Parwana was issued on 28/23 for conduct of keba. Stop. Thereafter, fresh Parwana within quote was issued by the village authorities on 5/9/2023 to hold keba. Stop. The respondent on 9/10/2023 filed an interlocutory application bearing IA 02 of 2023 in the connected letters of administration proceeding LA case number 6 of 2023 for staying the keba proceeding. Stop. This court not this court. Sir. The trial court by order dated 9/10/2023 suspended further keba proceedings ex parte. It was an ex parte order. by an ex parte proceeding. Stop. The said order of the trial court suspending further KEBA proceeding is challenged by the instant revision petition. Stop. Mr. So-and-so, learned counsel for the petitioner submits that relating to the same plot of land, a KEBA decision was held on 16/7/2023. And when the petitioner was not allowed to withdraw the rent of the shops and the respondents have forcefully taken the rent, the petitioner filed another complaint to call for KEBA hearing, wherein notices were issued on 28/23 and 5/9/2023. Stop. He further submits that the respondents thereafter filed an application for letters of administration relating to the same disputed property, which were, stop. He further submits the respondent filed an interlocutory application being IA number 2 of 23, wherein suspension of the further KEBA proceeding was sought for. Stop. He accordingly submits that the ex parte order is wholly without jurisdiction and manifestly illegal. Stop. Mr. So-and-so, learned counsel for the respondent, on the other hand, submits that the instant revision petition is not maintainable in view of CPC. In view of the amendment to section 115 of CPC, to the effect that revision petitions under section 115 shall not be maintainable against interlocutory orders. Stop. I have heard the submissions made at the bar and have perused the materials available on record. It appears that the LA case has been filed for issuance of letters of administration in respect of the same plot of land, which was already divided amongst the parties with a KEBA decision held on 16/7/2023. Stop. It would be just simply say pertinent to mention that under the provisions of the Assam Frontier Administration of Justice Regulation 1945, hereinafter referred as the Regulation 1945, under Regulation 40, it is the village authority who shall try all suits without limit or value in which both the parties are indigenous to the state of Arunachal Pradesh. Stop. Relevant provisions of the aforesaid regulation are quoted hereunder for ready reference. Regulation 24. You quote this, Regulation 24. then regulation 40, and then regulation 45, 1 and 2. Okay? A perusal of the aforesaid regulation indicates that pursuant to a decision of the village authorities, a provision for appeal is also provided. Stop. In the present case, admittedly, no appeal has been filed against the decision of the village authority within bracket KEBA dated 16/7/2023. Stop. The KEBA decision dated 16/7/2023 having not appealed within the stipulated period has attained finality and therefore cannot be reopened. Stop. However, it appears that against the same plot of land, a letters of administration has been sought for by filing the connected LA proceedings. Stop. It further appears that since the petitioner has not been able to collect rent in relation to the shop falling under his portion of the land in terms of the aforesaid KEBA decision held on 16/7/2023, the present, he has filed an application for holding KEBA meetings before the village authority. Stop. The summons to hold further KEBA proceedings has been assailed before the trial court in the connected LA proceedings by interlocutory application. Stop. Pertinent to refer to the decision of the Patna High Court in Saroj Kumar versus Manish Kumar and others, wherein the Patna High Court has held
Paragraph 16 onwards. ma'am.
yes. That proceedings of the partition suit cannot be stayed under section 10 of the Code of Civil Procedure during the pendency of the probate case, inasmuch as the aforesaid two proceedings are in respect of the same matter in issue. Stop. Further, don't say further. As regards the submission of the learned counsel for the respondent to the effect that revision petition is not maintainable against interlocutory application, the matter requires no further adjudication, as it is well settled that when revision petition is also filed under the provision of Article 227 of the Constitution of India, there is no restriction for entertaining such matter. Stop. A perusal of the impugned order, where is it? Page
It is at page, my lord, 118, my lord.
IA order.
IA order, my lord. 118.
Order dated 9/10/2023, passed by the trial judge, indicates that by an interim order, the Keba Parwana dated 5/9/2023, issued by the in charge head Gaon Bura of Alor, has been suspended until further order of that court. Stop. It appears that the aforesaid interim order has been passed without application of mind. Stop. Interim orders are not to be given merely for the asking. Stop. As discussed above, the subject plot of land has already been settled by Keba proceeding dated 16/7/2023. Stop. Hence, the order dated the ex parte order dated 9/10/2023 appears to be manifestly erroneous and hence has occasioned failure of justice. Stop. Having held so, comma, the order dated the impugned ex parte order dated 9/10/2023 passed in IA number 2 of 2023 within bracket in LA number 6 of 2023 passed by the Honorable District Court West Siang Alo is set aside and quashed. Stop. With the aforesaid observation, the revision petition stands allowed.
All right.
Disposed of.
Under 3.
You have an IA for suspension?
Yes, Lordship.
So let me issue notice.
Lordship. I just have one prayer between Lordship, a very small prayer. So Lordship may kindly look into page 142.
142?
142 of the criminal main petition.
Yes.
Here, Lordship, the learned court below has made an observation in the 4th paragraph. In subjail Bombay, if your Lordship has kindly find it, Lordship.
Yes.
There is lack of amenities for the convict. It is overcrowded. Hence, it is ordered that the convict be shifted to other district jail for serving sentence.
Yes.
Now, he is from Tezpur, Lordship.
Yes.
So, if he is sent to some other jail, there will be some difficulty. But he should not be sent more far, Lordship. That is only my prayer.
He should not be?
Sent more far. They are planning to send him to Teju. Teju will be more far, Lordship.
Have you filed any application?
No, Lordship.
Then you file an application.
Lordship.
Let me issue notice. In the meantime, you make an application.
Lordship.
How do you, otherwise,
Lordship.
it will be difficult for this court to give you that order, right?
Certainly.
You make an application. So I'm issuing notice in the criminal appeal as well as the IA.
LCR may kindly be called.
There is one IA, no?
There is only one IA for suspension of sentence
Yes.
and for the bail.
In the criminal appeal. Heard Mr. So-and-so, learned counsel for the petitioner, stop. Also heard MSL Higel, learned APP for the state respondent, stop. This is an appeal.
Under section.
Yes. This is an appeal
374.
under section 374 of CRPC against the impugned judgment and order dated 4/3/2024 and sentence dated 12/3/2024, passed by the learned Special Judge NDPS for the district of West Kemeng, East Kemeng, and Tawang district at Bomdila, Arunachal Pradesh, in NDPS case number 20 of 2023, arising out of Rupa PS case number 6 of 2023 under section 20C of the NDPS Act. Stop. Issue notice, admit. Who is
LCR may be
R2?
called for, Lordship. LCR may be called
Who
for.
is R2?
He's
R2
informant.
is the informant, Lordship. He
Registered
is a
agent.
police officer only. So I think my learned.
You take,
I'll
okay,
forward it.
issue notice, MS L Hege accept notice on behalf of R1 and 2. Stop. In the meantime, extra copies within the course of the day. In the meantime, let the scan copy.
Lordship, original but it's a convicted matter, Lordship. It's original copy LCR may be called.
Let the LCR be called for. Stop. List on.
After 4 weeks.
List after 4 weeks on a date to be fixed by the registry. Stop. It is submitted by Mr.
A. Bhattacharya, Lordship.
A. Bhattacharya, learned counsel for the petitioner, that in view of the lack of amenities for the convict in jail, in Bomdila sub-jail, comma, there has been an order to shift the convict to other district jail for serving the sentence. Stop. In view of the above, he had a submission has been made to not to shift the petitioner to a distant jail. Stop. Be that as it may, the petitioner is at liberty to file appropriate application, and as and when such application is made, such prayer shall be considered. Stop. In the IA also, you issue notice. But say there, IA is for suspension of the sentence. Okay.
Can IA be fixed in a little bit convenient date, Lordship? 2 weeks or?
Lordship, as per the IA, Lordship, this convict person, Lordship, already in the jail, Lordship, and doing the trial also.
Yes, yes.
So, Lordship,
Anyway, 4
it may
weeks.
be.
Okay, next.
Lordship.
Diploma.
Obliged, Lordship.
Yes. Up to date case diary. Yes, Mr. Bora, are you appearing?
Yes, 19.
This is that case?
Yes, my lord.
Have you filed your affidavit?
Yeah, we filed it on the
Where is
last
this?
occasion.
This is the IA, but where is the additional affidavit?
It was filed on last Friday, my lord.
Did
I was
you
informed
receive, Ms. Hege?
Lordship, yes, Lordship, I have received, Lordship.
The affidavit to put us. Where is the affidavit? Where is the affidavit?
I was informed that there was a simple mistake in one of the pages. It was not stamped while making the affidavit. So most of it they have corrected in, and it should have been.
Have you
filed.
Yes, Lordship, I have received,
Is
Lordship.
there any statement as regards where those checks are right now presently?
Lordship, as per their statement, Lordship, they have submitted before the Lordship, CGM in the court of the Impal, Lordship. But Lordship, actually,
In connection of what?
in concept, they have made complaint, Lordship, they have made complaint before the court, Lordship, and the subsequently court have issued for the investigation only, Lordship.
Show me that affidavit.
I have an extra copy.
But Lordship, during the Lordship, if although Lordship they have submitted there, but they can apply for the seizure memo, they can produce here also, Lordship, by the permission of the court, Lordship.
Where is that?
Seizure memo we have already produced.
Where is that statement? That they have
The
submitted
Para 7, page 36.
para?
7.
36, Lordship. Page 36.
The affidavit. Huh? additional, this is the. Internal page,
36,
internal page. Paragraph
paragraph 7.
7, page 6.
One side we have deposited in the seizing court, the other side has been seized by police subsequently.
Anything else? That's all, right?
Lordship, that's it. It's a bare contention, Lordship. But Lordship, here,
So earlier you had submitted that pursuant to the interim order, they had appeared and their statement under 161 was recorded, correct?
Lordship,
All right, and though the checks were asked, they were unable to submit.
Lordship,
But now it appears that these two checks, the original, they have already handed over before the court at Impal. And otherwise, another check has been seized
By
by
the
the
police.
police at Manipur.
Yes, my lord.
but
All right,
Lordship,
anything else?
Lordship, here, Lordship, they have mentioned the paragraph 10, Lordship, that they have wrongly, Lordship, that they have contended that they have appeared before the IO on the 4 occasions, Lordship. But as per record, Lordship, they have not appeared. Only once they have appeared, Lordship.
After the interim order,
Lordship, after they have never appeared.
they were not asked to.
No, Lordship, no, they asked Lordship. Even the IO they have verbally, they have communicated to the accused Lordship by telephony also, but they never appeared. They never turned up, Lordship.
Where is it?
Lordship, this
No,
the day
not in the additional affidavit, in the case diary. Where is the note of the
Lordship.
IO?
May I, lordship?
We have heard you, Mr. Bora. Please take your seat. You are Larik Yangbam Okendro Roy.
Yes.
Interim order was granted when? 23-1.
23-1.
Till the last updated CD, Lordship, they have never appeared. Only once they have appeared, they do with the bail bond and they have got the interim protection, Lordship. Although they have interim protection, they could have appeared before the IO for the submission, Lordship, whatever they have made before this court through the IA and all, Lordship.
Where is it the statement recorded under 161?
Lordship.
Flag it.
Okay, that is Lordship, earlier CD, Lordship. The first CD they have.
Yes, give me both. I call it.
Then we are ready. With the list of the losses, someone they have issued lawsuit.
Miss Hage, the summons that you are showing is in respect of them giving these checks, right?
Lawsuit.
Now you see the checks are before another court.
Lawsuit.
Just because it is in another court now, the IO cannot keep on harassing them also to produce it. You see, he has appeared in
Lawsuit.
pursuant to the court's order. Please be mindful of what
Lawsuit,
you are
yes,
submitting.
yes, yes.
Otherwise, this court will take
Lawsuit.
note of the conduct of the IO.
Yes, sir.
Because if the statement, these checks, has already been deposited in another court, and some checks have been seized by another investigating agency
Okay.
in another state, you cannot be pressurizing the accused to produce this. From where will he get it? Even the IO can obtain it from that court. Is there a bar for the IO to obtain it from that court?
Oh, okay.
Then now this court is concerned at this moment about what? The life and liberty of a citizen.
Lawsuit.
This court is not concerned whether one has to punish or not. That is not the object of the bail,
Lawsuit.
isn't it?
Lawsuit.
So as regards the object of the bail, namely whether he shall appear before the trial court or not, that we shall secure by giving some conditions. There is nothing to indicate that he will not do it. There is no apprehension raised by the IO that the antecedents are adverse or something. Those are not there. Merely one thing has been repeatedly saying that he has not submitted the checks.
Lawsuit.
He's been constantly saying that these checks are before the Imphal court.
No, no, sir. Earlier they have not
Correct?
committed like that lawsuit.
Anyway, right
Lawsuit.
now that is the position.
Yes, sir,
Therefore,
right now,
this
lawsuit.
court is inclined to grant anticipatory bail to the petitioner.
Lawsuit.
In future, if they do not cooperate, of course, you can come and inform the court, and that will be cancelled if they take undue advantage of the bail. Correct?
I'm also paying, sir. Any appropriate order may pass so
Yes,
that
yes.
this may be not pending
Yes,
anymore lawsuit.
Yes, yes. Heard Mr. R. Bodo.
R. Sekhar, Raj Sekhar.
Sorry, R. Shekhar. Learned counsel for the petitioner. Stop. Also heard MS L. Hege, learned APP for the state respondent. Stop. This is an application under section 438. Under section 438 of CRPC for granting pre-arrest bail to the accused person, Shri Larikengam Okenro Roy, who is apprehending arrest in connection with Jiro Police Case number 1 of 2024, registered under section 420-406-34 IPC. Stop. The brief facts of the case is that which paragraph have you mentioned the facts, Mr. Shaker? Okay. Is that on 15/1/2024, a FIR was lodged by one Shri Hege, but CEO, Managing Director, Jiro Valley Resort, alleging that one Hamam Purananda of Imphal has fraudulently withdrawn rupees 7,35,000 from the current account number 37219066,267 of Jiro Valley Resort from the SBI branch, Old Zero branch yesterday, i. 10th January 2024. Stop. It is the further case of the prosecution that the aforesaid check was withdrawn without knowledge and permission of the authorized holder of the bank. It is the further case of the prosecution that it is strongly suspected that the petitioner, who is the ex-general manager of Jiro Valley Resort, is involved in the matter as the checkbook was under his custody, and the check number 759108, by which the amount was withdrawn, was found missing when he returned the checkbook on 8th August 2023 after dismissal from the service in the month of July 2023. Stop. Accordingly, a case has been registered under section 420-406-34 IPC. Stop. Mr. R. Shekhar, learned counsel for the petitioner, submits that the petitioner has been falsely implicated in the matter and has no role to play. Stop. The case diary called for is placed before this court. Stop. MSL Hege, learned APP for the state respondent, submits that pursuant to the interim order passed by this court with the order dated 23/1/2024, the petitioner appeared before the investigating officer and his statement under section 161 CRPC has also been recorded by the investigating officer. Stop. She, however, submits that despite several attempts made, the subject checks has not been produced by the accused petitioner. Stop. In respect of the aforesaid submission made by the learned APP state, the petitioner has filed an additional affidavit before this court. Where is the affidavit? Wherein it has been clearly averred that the subject checks have been annexed along with the copy of the complaint filed by the petitioner under section 156(3) CRPC before the learned Chief Judicial Magistrate, Imphal, West Manipur. And another check has been seized by the Lamphal Police Station, Manipur. Stop. The relevant paragraph 7, 8 of the aforesaid additional affidavit is reproduced here under for ready reference. Stop. Then you're right. It appears that the petitioner has cooperated with the investigating officer by making himself present before the investigating officer for recording his statement under section 161 CRPC. Stop. It further appears that the checks which are the checks which are required to be produced by the accused petitioner are in the records of the complaint case. What is the number of the complaint case? I.e.
Complaint case number is criminal miscase investigation case number 3
Please provide the details.
Criminal miscase within bracket investigation case number 3/2023 before the CGM, Imphal West, Manipur.
Stop. In view of the aforesaid, in view of the aforesaid, custodial detention of the petitioner may not be justified for the ongoing investigation. Stop. Needless to clarify that the object of the bail is not punishment, but to secure the attendance of the accused petitioner during his trial by a reasonable bail amount. Stop. Accordingly, the interim bail granted by this court with the order dated 23/1/2024 is hereby made absolute, subject, of course, to the following conditions. make those conditions with the aforesaid observation and direction. This AB stands disposed of. Returned CD and up-to-date CD.
But no, there is an IA, in this case, we filed an IA. We have filed an IA regarding the subsequent orders by which we are directed to produce the 7/6.
So those
That-
IA will stand disposed of?
Yes, Lord.
Orders
Orders
the
will be-
IA, in view of the orders passed in AB so and so, the IA stands disposed of. This is item number
19.
19 also.
IA also disposed of, huh? Yes.
What's CD and bail hearing? Was it today's?
CD available? Ms. Hage?
Nasib, actually, that matter is handling by the G. Tado, Advocate G. Tado. He,
Yes.
Your
You are Mr. Ite.
Yes, your lordship.
Ite.
Yes, your lordship.
Yes, Mr. Ite.
Last occasion, we are directed to furnish the status report.
Huh.
And a charge sheet matter has been charge sheeted.
But it's such is it?
Yes, your lordship.
This is a
On,
bail application.
yes, your lordship.
Then let him appear.
Your lordship, it's a regular bail. Let the LCR be called for your lordship.
Lordship, section is 379 only.
When can you have it?
Your lordship, LCR has to be routed through registry, your
Next
lordship.
Monday?
Yes, your lordship.
From which court?
Lordship, this is a bail application already recovered.
Charge
She's,
sheet already, so just maybe.
379 only,
we'll
Lordship.
we'll give a short date.
Yes, your lordship.
Which court?
Moreover, the uncle of the
Your lordship, JMFC, your lordship, UPA, Capital Complex. Yes, yes, your lordship.
Wednesday. Let the LCR be called for.
Scan
to
copy
the
of LCR.
registry of this court.
Yes, your
From the court of
JMFC, Judicial Magistrate First Class,
ACM, Judicial.
Magistrate First
Magistrate
Class,
First class, UPA.
Capital Complex, UPA.
Capital Complex, UPA, to the registry of this court.
Yes.
Fix this matter on Wednesday.
Okay.
You send an instruction and you get it. Let's not keep these matters hanging.
Wait,
Life and liberty of the petitioners
Yes,
are at
yes.
stake.
obligation.
Yes.
Obliged.
Item number 21.
May I please the lordship?
Yes, Mr.
My lord, I am from Guwahati, my lord, due to unavoidable circumstances, my lord. This is a pre-arrest bail application, my lord,
Yes.
four petitioners.
Mr.
Yes,
Barbuya, just a minute. Is
Well-
CD available?
No, we have not received the case diary, your lordship, yet, your lordship. We have received the WT message from the concerned IO that he stated that he's on leave, your lordship, and praying for further time for producing the
Much
case diary.
time. Because it's an anticipatory bail and there is no interim order.
Maybe on Monday, your lordship,
Monday.
at least.
Mr. Barbuya, the concerned IO is on leave and that is why the CD is not available. I'm fixing this matter on next Monday.
My lord,
Call for this await CD list on Monday.
Yes.
Give the date.
Deeply obliged.
my lord, kindly interim order may be continued.
Next interim order, if any, shall continue to the next.
Obliged.
Deeply obliged, my lord.
376.
My lord,
Yes.
my lord, here, my lord, this petitioner, my lord, this accused, my lord, he surrendered by himself once.
Respondent number 2 has been served.
Lordship, I'm appearing for respondent number 2. I have been instructed this morning. So may I pray that at least I may be accommodated 3 days.
How much day?
3 or 4.
We fixed this on Thursday?
My lord, there is a difficulty, my lord. What happened here in my lord? Very unfortunately, my lord. As on my lord, it's going to be 82 days, my lord, after my arrest. At the maximum period is 90 days. Till now, no charge sheet has been filed. Now, my lord, till date, even the trial court, my lord, I filed my bail application in the month of 11th March 2020.
All right, Mr.
My lord.
Counsel, only
My-
because of Deepak Naik's judgment,
My lord.
because you're aware of the practice direction issued by the division bench of this court, right? That the informant has to be heard. Now, pursuant to the notice issued, the informant has appeared today, but he's asking for a day or two. So let us give him 1 day.
Tomorrow, my lord.
We'll fix it on Wednesday. Let him
Yes,
take.
sir.
Yes, I'm fixing this matter on Wednesday. No further adjournment is going to be granted.
Yes, ma'am.
May I pray for Tuesday?
No, this is tomorrow.
Second.
No. On Wednesday.
Madam.
You are for the
For the state, my lord.
state. Do you have the CD?
Yes, ma'am, we have.
Please retain it.
My lord.
CD received, retain the CD. Mr. So and so learned counsel appears on behalf of the respondent number 2 stroke informant or victim. Informant who seeks a day for accommodation. Stop. Prayer is allowed. List this matter on Wednesday. No further adjournments. In this matter, the mobile set was supposed to be
Yes,
handed
my lord.
over. Yes.
Deposited.
Has
sir.
the
In compliance of this order, my lord, yes, my lord, mobile has been seized, my lord.
mobile has been seized?
Seized, my lord.
To bring it on record, my lord, we have filed additional affidavit also.
Who has filed?
We have filed. There are so many circumstances, my lord.
1 second. The petitioner here is who? The girl with whom the husband was having an extramarital?
Yes,
My lord.
And what is the name?
Tichi Dimin.
Tichi Demin.
Hmm?
Tichi
Miss
Demin.
Tichi Dimin.
Demin.
Dimin, D-I-M-I-N.
T-E-C-H-I.
My lord.
Tichi
D-I-M-I-N.
Dimin. Admittedly, the husband was in love with the other person, and it appears that the family members also attempted that
To resolve the issue.
for marriage of the second girl,
Yes,
right?
ma'am. Yes, ma'am.
You are appearing for the informant? What is your objection?
That applicant sees the main country in this case, who is destroyed by discussed by many. So before that lawsuit, she has several occasions returned to their consequence to the deceased persons, my younger sister. So therefore, some of my family members also informed that several occasions this Dimin has instigated Abby to commit suicide to my sister. So mastermind main thing lead to that. Cause of death is lead by this Dimin itself. Moreover, that she has not only that person, not only that she has intentionally compared to commit suicide to my sister and damage family fees. So moreover, almost 9 years, both this my brother-in-law, that Taptama and Dimin, they were in relationship, but we really not know that we come to know later after the once we discuss was held on 9th of February. So thereafter also this Dimin has taken to instigated to commit to suicide to my younger sister. So entire this the cause of death of this my sister is lead by Dimin itself.
All right. You see, already this court had granted interim pre-arrest bail, subject to conditions. Now it appears the conditions has been met with. There is no violation of the condition. So,
My lord, on the first day when this matter was taken up, my lord, the interim protection was granted solely on the ground that she had to appear for a B.Ed examination, and which was on 28/3/2024. Now, as of today, my lord, it's been more than 1 month.
but pursuant to this interim protection, she has already appeared.
No.
She has also handed over the
Yes, ma'am.
mobile handset. Anything else is required? Because as per the investigation, there is nothing directly pointing out to the present petitioner to do an act for which the, you know,
My lord, to
there
my
is
very,
nothing as of now.
yes,
You
ma'am.
can point out.
To my very limited,
Because unfortunately, the incident has happened. A person has lost life, very unfortunate.
Yes.
This court has full empathy to the family members of the person. But that alone cannot be a ground to deny the liberty to a person or restrict the liberty of a citizen.
to my
The
very,
law is well settled.
yes, ma'am.
Unless and until the accused petitioner is convicted, he shall be presumed to be innocent. And the object of the bail is not punishment.
Yes, ma'am,
So
that's true.
show us if you need the petitioner for further interrogal custody. You need, because I don't see he
Yes,
has
ma'am.
already fulfilled. Is there
Submitted the mobile
anything?
phone.
Please submit to that
To
effect.
my very limited understanding of law, my lord, the very purpose of anticipatory bail application is to protect those people against whom a false allegation has been made. Now, if I may take my lord to page number 12 of the case diary, my lord.
Case diary.
Yes, ma'am. The statement of the witnesses recorded under 161 of the CRPC.
12.
Yes, my lord. Sister-in-law of the deceased.
Yes,
The relevant part is from page number 13, my lord.
yes.
If I may read, my lord.
This is Teshi Mana.
Yes, my lord.
She is the sister-in-law of the deceased.
Of the deceased, my lord.
Yes.
On being examined, she stated that the name and address mentioned above are true to my concern that in the month of February 2024, one day suddenly I was informed by Miss Techi Ania, wife of my husband, elder brother, that Tok Tama having extramarital affair with one girl, namely Miss Techi Demin, the present applicant who is before my lord, of Korea village, Sagali. And getting that information, I was shocked that thereafter family members were decided to settle the issue and called both late Techi Nime and Tok Tama at Sud village residence. And during the said discussion, Tok Tama admitted of having an extramarital affair with Techi Demin and further said that he would anyhow do marriage to Techi Demin. Thereafter, Sri Tok Tama started to doing arrogant attitude and later he threatened to assault late Techi Neme if she not allowed to marry Miss Techi Demin, and also warned dire consequences to family members of late Techi Neme Tok. That in this way, family meeting was not concluded at the evening at Sud village. That thereafter, one day, I don't remember the exact date, but in the month of February 2024, late Techi Neme Tok told me that Miss Techi Demin, instead of leaving Tok Tama, she always threatened dire consequences to her if she interfered in the extramarital affair. Further, late Techi Neme.
Threatening is to the sister-in-law.
Yes, my lord. Threatening to the lady who passed away, my lord.
To the lady who passed.
Who the disease, my lord. Interfered in the extramarital affair. Further, Techi Nime told me that one day Miss Techi Demin telephonically called to her and said in Hindi word, "Tum abhi tak jinda hai kya? Kyun nahi mara hai abhi tak? Jaldi se mar jao na atma."
Have you sent the call records?
Yes, we have already given everything to them.
That is awaiting.
We have given.
That has not come.
Yes, maybe.
But CDR
Sorry,
is being yet.
you are for
Is,
the
yes, my lord.
case.
CDR is yet to be obtained, my lord. CDR.
Case record.
Yes, my lord. Yes,
Sorry,
call detail.
data.
Call detail records, ma'am. That it is also told me that her husband Tok Tama was habits of late night coming at home, and whenever came late night at home, then he always do mental and physical torture to her by kicked and punch in the body of late Techi Nime Tok. Husband, my lord. It was also narrated to me that Tok Tama always demanded money to her, and if she not fulfill his demands, then Tok Tama used to beat her mercilessly. Further, it was also told me that Tok Tama always instigated her to commit suicide and demanded dowry, local beads, ornaments from late Techi Nime Tok. That after passing some days, again late Techi Nime Tok told me that Miss Techi Demin threatened her to kill and also instigated her to commit suicide. And it was also told me that if late Techi Nime died, then Miss Techi Demin could able to occupy the entire property of Tok Tama. That thereafter, suddenly at the evening of 21st day of March 2024, I was shocked to know that late Techi Nime was found dead
at Ragi Nala area, Lekhi village, and getting that information, I immediately rushed at her residence, Lekhi village. That late Techi Nimetok was compelled to
Alright.
commit suicide. I won't
Yes.
trouble my.
You want to say something?
Yes, my lord. My lord, may kindly come to the additional affidavit that we have filed today. Otherwise, my lord, there was no case. I don't know,
Yes.
since I am not accessible to the CD, my lord.
Yes, what do you want to show from the additional affidavit?
Kindly come to page 6, my lord.
Yes,
Because the circumstances, my lord, to prevent me from even entering into the PS so that my interim bail could be cancelled, my lord. There are so many instances. Page 6, this is on record, my lord.
yes, then,
Thereafter, my lord, 27 interim it was granted. Since my house, it was ransacked. So 28, I have written to the SP this letter. Thereafter, 29, I attempted to FIR before the IO. There also, the PS, it was get out. And everywhere they tried to assault me. So thereafter, page 7, my lord, letter dated 33/2024. Herein again, I have narrated everything, what had happened on 29, my lord.
yes. Finally, you have your statement has been recorded.
My lord, thereafter, what happened? Immediately on first, it was listed. Then,
How are those facts relevant, Mr. Counsel? We are considering the grant of AB. There is no allegation has been leveled that you are not cooperating or you have not appeared. They have said that you have.
that's what, my lord. On first,
Yes.
when it was listed, my lord, the learned PP's objection was that she is not cooperating.
Anyway,
See-
today that
Yes.
submission is not made.
Thereafter,
So
my
this
lord-
court will not go into all that.
Okay, my lord.
Alright.
Thereafter, on the last occasion itself, again,
No, but this today that submission is not made when at the time of hearing the AB.
My
So
lord.
this court is not going to that aspect of the.
my lord,
matter.
last time objection saying that mobile it was not surrendered.
Now you have already handed over.
My lord.
Very well.
And then another
Very well.
objection, my lord, that I have not appeared in the exam. Kindly come to page.
No, that also this
No, I have
court
not
will
met
not.
that
go into.
allegation, my lord.
Anyway, those matters you don't worry. This court
My
will
lord,
not go.
other than that, my lord, my respectful submission is that since section involved is 306, and without there being any section, additional sections like section 34, 120B, how do this applicant be connected with this case, my lord? Very interesting. If it has come in the subsequent, updated CD, that any sections that is added, section 34 or 120B, my lord, then case would have been different.
All right.
So allegation, my lord, is there, and then witness under such circumstances to get punished someone or to get detained someone may say so many things. So at least the statement of the main accused person and this applicant and the other witnesses, independent witnesses who are not connected with the victim's family. My humble submission, my those may be kindly taken
All right.
note of, and then
With the permission of
since
my lord.
I have appeared, bail bond executed, and then I am cooperating with the case. So
I shall come back in 5 minutes and pass the order. Heard Mr. So-and-so, learned counsel for the petitioner, stop. Also heard
Mr. J. Sri.
Mr. J.
PP.
Shereen, learned APP,
PP.
learned PP
Yes.
for the state respondent, and Mr. T. Topu for the complainant, stroke respondent number 2. This is an application under section 438 of CRPC 1973 seeking pre-arrest bail to the petitioner i.e. Ms. Techi Dimin, who is apprehending arrest in connection with Nirjuli PS case number 21 of 24 registered under section 306 IPC 1860, arising out of FIR dated 21/3/24, lodged by one Shri Techi Pekhi Tada. Stop. The brief facts of the case is that on 21/3/2024, an FIR was lodged alleging inter alia that his sister, namely late Techi Nime To, was found dead near water tank on that day at 8 p.m. And his sister always complained that her husband, co-accused is having extramarital affair with the petitioner. And when his late sister protested about the affairs, her husband, co-accused, threatened her to kill her. Stop. It is the further allegation of the prosecution that on several occasions, the husband, co-accused, instigated her to commit suicide to his late sister. Stop. Accordingly, an FIR was registered. Stop. The case diary called for is placed before the court. Stop. Mr. So-and-so, learned counsel for the petitioner, submits that pursuant to the interim pre-arrest bail, the petitioner tried to appear before the investigating officer on 28/3/2024
29.
and 29/3/2024 respectively, but on both occasions, due to the protest made by the family members of the deceased before the jurisdictional police station against the petitioner, the petitioner was unable to appear. Stop. He further submits that the petitioner is falsely implicated in the offense alleged. Stop. He further submits that the offense is under section 306 alone of IPC and no provision of section 34 has been added in the matter. Stop. Mr. So-and-so, learned counsel, learned PP for the state respondent submits that the petitioner thereafter has appeared before the investigating officer as per the interim pre-arrest bail granted. Stop. He further submits that the statement of the petitioner has been recorded under the provisions of section 161 CRPC. Stop. He further submits that on the date of appearance by the petitioner, the petitioner was directed to hand over the mobile handset as during interrogation, it has come into light that the petitioner, by using the aforesaid handset, used to threaten the petitioner, threaten the victim. Stop. However, despite of attempts made by the interrogating officer, the petitioner did not deposit the mobile handset. Stop. Pursuant to this court's direction dated 24/4/2024, the petitioner handed over the mobile handset to the investigating officer. Stop. It is submitted by the learned PP that the call data records are yet to be received against the said mobile handset. Stop. He further submits that the investigation is at an active stage and the custodial interrogation of the petitioner is of utmost essential. Stop. He further submits that that's it. Thereafter, you say, Mr. Your name? So-and-so learned counsel for the respondent number 2 / informant submits that that it is because of the active role of the petitioner that the victim has taken such a huge step to kill herself. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that the investigation is at an active stage. Stop. It further appears that from the statements, especially of one Techi Mana, sister-in-law of the deceased victim, it appears that the petitioner has played an active role for which the incident has occurred. Stop. It further appears that there are sufficient materials on record implicating the petitioner against the offense or against the offense alleged. Stop. It further appears that the petitioner has telephonically called the victim and threatened her, because of which it is believed that the victim has taken such a step in her life. Stop. The call data of the mobile handset is yet to be ascertained, is yet to be sent by the
Investigating authority.
by the
IO.
by the where have you sent it for the
Requisition, my lord. Requisition has been sent.
is yet to be received. Stop. It may be noted herein that during the appearance of the petitioner before the investigating officer, the petitioner did not deposit the mobile handset despite of several attempts made by the investigating officer to recover the same. Stop.
In that case, my lord, my affidavit, additional affidavit, I have stated the reasons, my lord, that may be kindly taken note of, my lord. Kindly come to page, my lord, 11, my lord.
In this connection,
Page 11.
the petitioner, by filing an additional affidavit, has stated that
She went to New Delhi PS on 11/4/2024, 13/4/2024, 17.
that though the brother of the petitioner had tried to hand over the said mobile handset, but the investigating officer refused to receive the same. Stop. Be that as it may, comma, it appears that the investigation of the case is at an active stage. Stop. The custodial interrogation of the petitioner appears to be essential to unearth the truth. Stop. That being so, this court is not inclined to grant the anticipatory bail to the petitioner at this stage. Prayer of AV rejected. Interim order stands vacated. Past early sentence. CD returned. Sorry. Next. Yes, order rejoinder. You filed.
No, my lord, the IA is for, my lord, condoning a delay of 4,000.
There is an IA.
Yes, my lord. For condonation of delay of 4,920.
What is this office note about rejoinder? This is in the rejoinder to be filed where? You don't need to file any rejoinder.
Rejoinder has been filed already, my lord.
Five. How many days delay?
4,920 days.
4,000.
Yes, but I will.
4,000?
4,920 days.
920.
Yes.
4920.
My lord.
That's a long delay.
That's a long delay, my lord.
Filing what? For filing?
In filing the connected civil revision petition.
Civil revision.
Yes. My lord, in terms of a leave granted by this
Mr.
honorable.
Singh, you are objecting?
Yes, I am objecting, ma'am.
And yes.
In terms of a leave granted by this honorable court, we have filed an additional affidavit on, my lord, 23rd of February 2020. That may be kindly perused, my lord. It's in the
Additional
IM.
affidavit?
In the IM, my lord.
Yes.
23/2/2024.
Affidavit of justice service, then
It's in the last part. my lord. Additional affidavit.
yes. Yes,
My lord, may kindly have page 9, my lord.
the earlier AB disposed of her. Page
9, my lord.
of the additional affidavit.
Yes. Now, my lord, the applicant petitioner, my lord, had instituted a money suit, my lord, against the FCI as well as the state of Arunachal Pradesh, claiming, my lord, more than 4 crore 60 lakhs for supplying this food grains, my lord. Now, that was dismissed by this order at page 9 by the fast track court. at
Money
Dams-
suit is dismissed, rejected.
Yes, yes.
Hmm.
27/5/2008. Only on the ground that my claim has not been admitted by the
This is
respondent.
on merit. Why,
Yes.
what is the grounds for 4,920 days?
So I'm
delay?
coming,
Where's the
ma'am.
explanation
I
that
am
you
coming,
maintain?
I'm coming, ma'am.
Yes,
Thereafter,
let
ma-
us be confined to the
Yes,
grounds.
yes. Then my lord will kindly have page 18, my lord. Against this rejection order, we filed an interlocutory application seeking review of
Yes.
the order dated 27/5/2008,
Yes.
along with the condonation application. That was also rejected, my lord, by this order at 1/12/2009.
Yes.
Immediately, we filed a civil revision petition before this honorable court. 2 civil revision petitions assailing this order dated 1/12/2009. Now, my lord, when we filed CRP 29 and CRP 30 of 2009, when these 2 CRPs were filed, there were various other civil revision petitions filed by the FCI before this honorable court challenging the jurisdiction of this fast track courts on the principal ground that the Bengal Agro Civil Court Act is not applicable to the state of Arunachal Pradesh. Therefore, they do not have civil jurisdiction. So these matters, my lord, the principal case was main case CRP 14 of 2019. This kept pending till 2022. My 2 matters were tagged along with them. Unfortunately, my lord, when we filed the CRP, we challenged this order 1/12/2009 in the IA. But inadvertently, my lord, the earlier set of counsel did not put to challenge the order dated 27/5/2008. Ultimately, my lord, this honorable court at page 19.
Page 9 is the 27 order.
Yes, my lord.
What is the date of the order?
27/5/2008.
This was inadvertently not challenged.
Only the order dated
27/5,
Yes,
2008.
8. Yes, that was not challenged.
Yes.
We only put to challenge the order dated 1/12/2009. So, my lord, ultimately CRP 14 was decided on page 19, my lord. 28/9/2021. In the meantime, the Civil Courts Act was enacted in the state of Arunachal Pradesh. So all these matters pending before the earlier fast track courts were remanded to the civil courts. After this only, my lord, my CRP was taken up at page 2023. Page 23. ma'am.
Yes.
This is by an order dated 7/2/2022. Your lordship may kindly come to page 28,
Yes.
paragraph 5. The 1/12/2009 order has been interfered with on the ground that it was a cryptic order. Then my lord will have paragraph 7, my lord.
Paragraph?
7.
Hmm.
It would now be open for the petitioner to seek appropriate remedy before the appropriate forum against the judgment dated 27/5/2008. That is how the delay, my lord. It is an inadvertent mistake on the part of the earlier set of counsel.
So what does paragraph 7 means?
It says because we did not put to challenge the
The 25.
27/5 order.
27/5 order.
Yes.
Now, as per this order, you are at liberty to
Yes.
put that under
Yes,
challenge.
that is how we have filed the civil revision
And,
petition, but there is
when
that.
did you file that? This
That
order,
was in time, madam,
the-
immediately.
this order was passed on
Passed on
7/2/22.
Yes, madam.
When did you file that?
Just a moment. madam.
So you are saying that you have been
Yes.
inadvertently you were spending your time before another forum.
Not another forum, my lord, it was before the right forum, but inadvertently we did not put to challenge the main order.
Because which now,
Yeah. Liberty has been granted now.
the relief which you are required
Yes,
to be given cannot be given.
Yes.
Therefore, you are required to put that under challenge.
yes, exactly, my lord. My lord will kindly consider.
Now,
The-
when did you file that?
My lord, just a moment. 24th February 2022.
24
February 2022.
to 22.
Yes.
So this is within time.
Yes, madam, this is within time.
Civil revision.
Yes.
Yes, Mr. Singh? What is your
Judgment
objection?
was on 7/2. It was on 7/2. My lord will kindly consider.
I
My
come
lord,
back to you if, for you have a right to reply.
May it please your lordship. My lord, may come to paragraph 7 of my affidavit in opposition. My humble submission is that the petitioner has
One second,
always.
1 second. The rejoinder is here, but.
No, my
in
affidavit,
opposition,
first affidavit.
That
in
is not.
opposition.
Even opposition, what is this?
this additional affidavit was in fact filed after all these rejoinders and prudential exchange.
but
I was lately engaged in this case.
Affidavit in opposition from side of Patna.
No, no, no.
Mr. Das, for which matter are you waiting? 35. Hearing matter.
Yes.
I will wait. I don't think it's there, Mr. Singh.
Let me check.
If it was signed on
Yes, we
28th
can
of
also
July.
have a look.
28th of July.
Of 2022.
Yes.
Yeah, that's an EQ side. Mr. Panging, you can
Yes.
have a look at the CRP file in case it is there.
I have received a copy, but the file notings indicate objection not filed.
So then let the registry verify. I can post it tomorrow, Mr. Singh. Are you,
Tomorrow.
you want it tomorrow?
Tomorrow I am here.
Then I'll post it tomorrow. In the meantime,
Otherwise, I have
It
received.
may so happen that my clerk has not filed because in another case it has happened, my lord.
check it. You check.
Yes,
If
I will
it
check
has
with my.
To be filed, you filed it before the matter is taken tomorrow and call for the affidavit if required. All right. And Mr. Panging, you also ask your junior to check with the registry.
Man, absolutely.
It is submitted that an affidavit in opposition has been filed in the IA on behalf of respondent number
6, 7 and 8.
6, 7, and 8. Stop. However, the same is not on record. Let registry to verify and place the same on record. List the matter tomorrow.
Obliged.
Yes, additional affidavit filed.
Lordship, this is an petition under 480 for quashing of FIR based on settlement. Your Honor, this is a joint petition filed.
It's a joint petition.
Yes.
There has been a compromise.
Yes.
Where is the compromise?
My lord, it's page number 15.
Which number?
15, 15.
Mr. Ite, it appears there is a compromise.
Yes, your
I
lordship.
will look, otherwise, if we can dispose it of.
Yes, your lordship. And your lordship, on last occasion, even the MLC was called for. And as per the MLC report, the injury is simple injury, your lordship.
Simple injury.
Yes, your lordship.
So this complaint is between who is Taksing Yari?
The complaint.
Complainant.
Yes.
And Tar Sumpa,
Tarsumpa is the accused.
and number 2, 2, 3, 4, they are all accused,
Yes.
The company remain accused, your lordship.
co-accused.
Yes, your lordship. Basically, it's extramarital affair dispute, your lordship.
So now parties have entered into amicable settlement.
Yes, yes.
Are they related? Is the husband-wife?
Yes,
Husband-wife?
yes, your lordship.
Huh?
The husband is having an affair with the victim, your lordship. Complainant, your lordship.
All right.
For that, the wife and the
Okay.
other wife.
Heard, Mr.
Jikato.
So and so, learned counsel for the petition, learned counsel for the petitioner. Stop. Also heard, Mr. You are T. Ite, right?
Yes, your lordship.
T. Ite, learned APP for the state respondent. Stop. This is a joint application filed under section 482 of CRPC for compounding the non-compoundable offenses between petitioner number 1 and petitioner number 2, 3, 4, and 5, and for quashing of the FIR, which has been registered as Itanagar WPS
Yes.
number 01 of 2023 in terms of the compromise settlement arrived at among the petitioners. Stop. Mr. So-and-so learned counsel for the petitioner submits that the complainant, who is the wife of petitioner number 1, has entered into a settlement with the petitioner number 2, 3, 4, and 5, and has amicably settled the differences between the parties. Stop. I have heard the submissions made at the bar and have perused the efforts and perused the records available. Stop. It appears from the settlement deed enclosed as Annexure 3 to the joint application filed by the complainant stroke petitioners, complainant stroke accused, that a compromise has been amicably entered between the complainant and the accused. Whereafter, the differences between the parties have been mutually settled. Stop. It further appears that the petitioner number 1 stroke complainant and petitioner number 2 stroke accused are husband and wife, respectively.
No, they are not husband-wife, your lordship. The complainant victim, she is having an affair with the husband of petitioner number 2, your lordship.
Don't say that, delete that. It further, in view of the aforesaid settlement entered between the parties, comma, for the ends of justice, this court is inclined to quash the FIR dated, FIR number, where is the number? FIR dated 1/2/1/2023
Yes.
in Itanagar Women Police Station case number 1 of 2023 under section 451, 326, 427, 342, 506, 34 IPC. Stop. Anything else? That is the FIR.
Yes.
Ordered accordingly, disposed of.
Obliged.
Awesome.
Yes, respondent 2 and 8 affidavit service has been completed. The office note indicates that service in respect of 2 to 8 is awaited.
My lord, it was served there in Guwahati.
So, but see, either you file an affidavit of service or otherwise this court will have to go by the office note.
My lord, my lord.
Await a service report in respect of respondent number 228.
My lord.
List
My lord, 28 May, my lord.
on 28/5/2024.
My lord, there's an interim order. my lord.
Interim, if any, shall continue till the next date.
Deeply opposed.
Yes. Where is your affidavit of service in respect of 1 and 2? Have you filed, petitioner?
Not filed.
Not filed. Why?
Respondent verbally informed that they have already got copy.
No, no, but you are required to file the affidavit showing proof of dusty service. Anybody appearing for 1 and 2?
No, madam, I'm mentioning on behalf of Mr. R. Boraman. She is the standing counsel for CBSE.
For respondent?
Madam,
You don't know?
No. She has
This is the
requested.
unusual practice that this court have noticed in the Itanagar bench where counsels appear but are not aware of which respondents they are representing.
No, madam, she
One
just
must
called me up.
Wherever, if you have taken taken the responsibility to stand before this court, then minimum courtesy is expected that one is aware of the respondent one is going to make a request for. Anyway, it appears that the affidavit regarding proof of dusty service on respondent number 1 and 2 is not yet filed. Stop. Let the same be filed within a period of 2 weeks from today. List after 2 weeks on a date to be fixed by the registry.
Right.
Number 28. Yes, the money execution case.
Yes. Well, here in this case, in the management case, the warrant of warrant of arrest was issued by the executing court.
Yes.
And I am praying before your lordship is this, that warrant of arrest may be recalled.
Who is appearing for the?
I'm appearing for 1 and 2. Yes.
Others.
Yes.
Because the facts is this, the petitioner took a loan of rupees 10 crores from the bank. And he has failed to repay the loan.
You have taken loan of?
Rupees 10 crores.
10 crores, yes.
But he has failed to repay the loan. Because he was busy and he was contested the last general election. In the meantime, the bank issued a certificate to the Bakizai officer. And Bakizai, that proceeding was continued. Then the Bakizai officer sent the matter to the local adalat. And local adalat, it was decreed, the awarded, the certificate was issued for 10 crores. And accordingly, the execution cases proceeded. In the execution case, the petitioner appeared and he agreed to pay the amount. But he is not able to pay the amount because
Have you filed anything before the?
there was a mortgage property.
No, because since you had made an assurance that you will make the payment.
Yes.
Thereafter, you had failed.
Yes.
Now, at that stage, did you make any application seeking for some more time? You have not done it.
We have taken time, madam.
You have?
We have prayed for extension of time
You have made a prayer for extension?
before this honorable
No,
court.
no, before the executing court where the warrant of arrest has been
Page,
issued.
page
This is
47.
because you did not keep the assurance. That is why the impugned warrant of arrest has been issued.
Yes.
Correct?
Yes.
Page?
We filed an IA at page 47, your lordship can see.
Yes.
Sorry.
This is before
48,
this court.
48, madam, sorry. An application regarding the inability to sell the mortgage property and in connection to the awarded to so and so.
This was filed on? When was this filed?
12/4.
The same day when the
12/4?
2024.
24. And on that same day, the impugned order was passed. Yes. You're for the bank.
Yes.
We'll state this because they want some time. There is already a settlement. Now they want some time. What is the prayer in this eye?
Kind of see, the settlement was in the 2019, madam.
Yes, but they want to sell the mortgage property to realize its outstanding dues. We can, if a time frame is required, I can say that let this order be stayed. Let the executing court pass necessary order in this application.
This application has been rejected, madam.
Yes, but without considering, you see, it simply said. there is no effective consideration of the reasons given by the petitioner. Petitioner is saying he needs time to sell the mortgage property.
Several times he's sought time, madam, that's why.
No, at that
This
time
this
he
was
was
not the first
busy-
time. It was.
At that time, he was busy in connection with the election. He was a candidate in the last general election.
And he has already sought time, madam. This has to reflect in page 53.
Another thing is this, my lord, by keeping the judgment debtor in jail,
How much time do you need?
6 months.
This 2019 matter, madam.
All right, this court will do like this. I shall send this this matter back to the executing court. I will stay this for the next 6 months period. If they don't make the payments, this order will come into life.
That's a public depositors amount, madam. Depositors amount and did this, one of,
Just staying it for 6 months so that let them make an effort. If payments cannot be made, then the civil warrant of arrest shall be issued. All right.
2019 lordship.
Yes, I have
kind
understood,
of-
but since there has
Based-
been already a settlement, you agreed for a settlement. Now they are asking for 6 months' time. You give them a 6 months' time. You are interested in the money.
Of course,
uh,
lordship will kindly peruse the date,
otherwise,
page 37.
If you want, I can stay this order and post this matter for hearing. If you want, I can do that, or I can dispose it of by giving 6 months time to make the payments.
We may be given chance to file an affidavit.
All right, fine. Heard, Mr.
Yes, yes, sir.
So-and-so learned counsel for the petitioner. Stop. All you are appearing. Assisted, senior counsel assisted by. Please give an appearance slip. Also heard so-and-so learned standing counsel.
Yes, ma'am.
Arunachal Pradesh State Cooperative FX Pen Limited. Stop. This is an application under Article 227 of the Constitution of India, assailing order dated 12/4/2024, passed by the learned civil judge senior division, Capital Complex UPR, in money execution case number 4 of 2020. Stop. It appears that there has been a settlement between the parties in connection to the proceedings bearing CR number DC-1cc/CR/11/12/10/2018, which was pending before the EAC cum certificate officer Itanagar. Stop. It appears that the petitioner, by an application dated 12/4/2024, sought extension of time to allow the respondent stroke decree holder stroke petitioner to sell the mortgage property to realize its outstanding dues. Stop. The executing court, with a order dated 12/4/2024, rejected the said prayer and directed issue of civil warrant of arrest against the petitioner. Stop. The said order has been put to challenge in the revision petition. Stop. Notice was already issued.
Yes.
By order dated 26/4/2024, notice has been issued in the matter. Stop. Mr. So-and-so has appeared today on behalf of the bank respondent. Stop. In view of the fact that on 12/4/2024, an application for extension of time, in view of the fact that Despite sincere efforts made by the petitioner, he was unable to sell and dispose of the mortgage property. In order to repay the loan, in terms of the settlement arrived between the parties, comma, the executing court issued the warrant of arrest. Stop. Prima facie case has been made out by the petitioner, and in view of the same, in the interest of justice, in the interim, this court states the order dated 12/4/2024 passed by the learned civil judge senior division, Capital Complex, UPR, in money execution number 4 of 2020. Stop. Till the next date. Until further orders. Stop. List after how much time you want?
3 weeks.
Mr. So-and-so, learned standing counsel, so-and-so, such and such bank seeks 2 weeks time to file counter affidavit. Stop. Let this matter be listed after 2 weeks on a date to be fixed by the registry.
Obliged.
28 and 29.
29 is matter he took a loan of rupees 10 crores. And they issued a certificate to the Bagizar officer, 10 crores and 6 crores.
29.5. Yes.
The 6 crores I am not entitled to, not liable to pay. Because there are 2 certificates issued. One is 10 crore and one is.
Warrant of arrest is issued.
Yes, madam.
That is where? Page?
Page 51, 12/4/2004.
And where is your application for time?
Before that, madam. Page 47. IA number 33, page 47.
Here, this also, here, you had prayed for settlement.
Settlement, because the
And because of the mortgage, the same reason.
same reason, and another thing is this, we have to raise a dispute so far as this 6 crore is concerned, because already a certificate of 10 crores has been issued.
So you are admitting how much?
Here in this, in so far 6 crores is concerned, we are not liable to pay.
You're not liable to pay.
Not liable to pay. That point, we may be allowed to raise before the executing
No,
court.
no, this court will not go into all that. But you have entered into a settlement. The settlement is to what amount?
6 crores.
6 crore. Huh?
6 crores, 80 lakhs.
6 crore. So then same order.
Yes. It is
Same order. Ashwai, only here, the date. When did you file this application?
Same.
Which date?
12/4/2020.
Same date.
Same day.
So all that will be same. Only money execution cases number 4 of 2020.
And IA number 33, which the petitioner filed before that.
It is there in your prayer. The details.
Page 47.
Check the details at page 13. IA number?
33/2024.
Where is it stated?
Or page 47.
Miss case number 33 of 24, it says.
Yes.
Yes.
In the review note, it has been mentioned as IA number 33 of this.
Yes, 33. So it is IA number is 33 of 24. You will get the details at page 51. Yes, next matter.
I live.
Number 33.
Yes, Mr. Ife. 80 cards, it shows respect R2, services complete?
Not complete, but otherwise, your lordship, the IO itself is the R2 here, your lordship.
You are
He,
representing? Yes.
I have no any instructions so far whether
Your instructions then?
I have to take instruction from the IO.
Instructions, in
Yes.
that case, we will take the service to be completed and can proceed further with the criminal petition.
Yes, your lordship. Yes, your lordship. Otherwise, your lordship, here is a gross irregularity so far as the procedure is concerned, because 2 bail application has been cancelled in the 3rd case.
It appears from the office, Masha, it appears from the office note dated 26/4/2024 that the AD card in respect of R2 is still awaiting. Stop. However, it is submitted by Mr. T. Ite Learned APP state that he may be allowed to take instructions from the investigating officer stroke R2 as whether the state can represent. Stop. Prayer is not opposed. List this matter after 1 week on a date to be fixed by the registry.
Okay.
My lords, it may be fixed on third May.
All right.
Okay.
Not third, after third.
6th on 6th, your lordship, Monday.
Masha, six.
Deeply obliged.
Yes, next. Same?
Yes.
31 also same.
Same, your lordship.
Yes, respondent number 6, service. What's the status?
Your Lordship,
It's a condonation application.
no, Your Lordship, in this item number 32, I am appearing on behalf of J. Zongluju, counsel for the appellant.
32?
32, yes, Your Lordship.
Yes.
It's a criminal appeal which has been filed along with IA.
IA is for?
IA is for regarding the condonation.
How much delay?
Delay is, Your Lordship, before delving into that, I would.
How much delay? You have filed a delay application, you don't know how much delay?
Delay is 30 days.
30 days delay.
30 days, Your Lordship.
Are you objecting, Mr. Ite?
No, your lordship. If it is a regular appeal,
So we'll condone the delay.
yes, your lordship.
Where have you stated the grounds, paragraph?
Your Lordship, before going further, since I'm not the main counsel in this matter, I'm just appearing on behalf of J. Zongluju. So I would like this matter to be fixed for any short date. The
I'm
reason,
disposing of the application in your favor. You want time or you want a favor, you want me to condone the delay? Choice is yours.
Your Lordship, without the instruction of my senior, I won't be able to.
It's very unfortunate that the bar members is not at all following what the court is asking. When this court is agreeable to condone the delay,
Okay,
why
Your
should
Lordship,
this matter be unnecessarily kept
I'm
pending? What
Your Lordship, I'm
instruction do
highly
you want
obliged.
from the council?
Your Lordship, I'm so sorry. I'm highly obliged for condoning it. Thank you, sir.
Unnecessarily, a criminal appeal is going to be pending. Your name? Heard MS so-and-so, Learned Counsel
T.
for the
Mary.
petitioner. Stop. Also heard Mr. T. Ite, Learned APP for the state respondent. Stop. This is an application under Section 5 of the Limitation Act 1963 seeking condonation of delay in filing appeal against the judgment and order dated 23/1/2024, whereby the learned session judge for the district of East Kamang, West Kamang, so-and-so at Bomdila in session case number 8 of 2021 had convicted the appellant under section 302 of the IPC for life imprisonment along with a fine of rupees 20,000, read with under section 27(1) of the Arms Act for 7 years of rigorous imprisonment along with a fine of rupees 5,000. Stop. In default of payment of fine, the appellant has directed to undergo 3 months simple imprisonment in addition to the above. Stop. Just check paragraph. Cost title, the first one.
Your lordship, if it is live imprisonment, then it has to be placed before the division bench, your lordship.
Is it?
Up to 10 years, your lordship, single bench has a jurisdiction. If it is more than 10 years, then division bench, your lordship.
Then you cancel this order and say list before appropriate bench.
Yes, your lordship. Deeply obliged.
Yes, R6.
My lord, we had taken
Still awaiting.
still awaited, man.
Await service report in respect of R6. List after 3 weeks on a date
My
to be
lord,
fixed by the registry.
my lord, let it be listed on 16th of May,
All right.
May, my lord,
All right.
and we'll
6
take
weeks.
fresh steps, my lord.
In the meantime, petitioner may take fresh steps in respect of R6 and file affidavit of service thereof.
My lord.
Okay?
Fresh step. Yes, sir, Dusty, my lord.
Dusty.
Obliged.
We come back at 2, my lord.
I will stop.
Oh. What is this RFA?
My lord, yes, we'll come back at 2, my lord.
Mr. Das, in your matter, the other side is ready?
Yes. Lordship, I'd like to mention item number 39.
Mentioning is at 10:15, not
Yes, Lordship.
now.
This is unlikely to reach, Lordship. That's item number 30.
Why is that prediction?
Because Lordship, item number 34 and 35 is going to take a lot of time.
39.
39, Lordship.
You are for?
For the petitioner,
As prayed for by Mr.
V. Jamo,
So and so learned counsel for the petitioner, list this matter after
a week.
on a date to be fixed by the registry.
They say interim, Lordship. that
Interim, if any, shall continue till the next date.
Deeply obliged.
Item number 1, bail application number 43 of 24. It's a VC matter.
Sorry, concentrated, you should hit all the. Good evening, Your Lordship.
Yes, Mary, have you received the copy of the charge sheet?
I did, my lord. I have gone through the charge sheet, a copy of the charge sheet. I believe that my lord have gone through the copy of the charge sheet as well. And as I suspected, my lord, the case of the petitioner that we have dealt with in another case is not similarly situated with the present case. In as much as the person, the petitioner herein, is the mastermind and have played an active role in making the transaction making the transaction from smuggling the seized articles from one place to another.
Ms. Mary, where in the case diary it has been mentioned that the petitioner, because the petitioner here is one Faizul
Yes.
Faizul Islam, correct?
Yes, correct.
Now,
Lord.
where are the materials to indicate that he is the mastermind in this matter?
My lord, I have gone through.
I have seen one of the statements of one of the accused, which is at page 18.
Yes.
In the, I think these are part of the charge sheet.
Yes.
Copies which has been sent to me from the office. It
Yes.
appears he has given statement wherein
Yes.
he said that it was Faizul Islam who called him and asked him and said that he wanted to buy some heroin and
Yes.
repeatedly was asking, and accordingly a shipment was delivered to Faizul.
Yes.
Is this
Yes.
the material? Anything besides this?
My lord, I have gone through the copy of the charge sheet, that a small charge sheet that is filed, not the statements.
You don't
but
have
then
it. Have
they
you
have
got?
they have sent me the PDF of the charge sheet, my lord. In the charge sheet,
You don't have the entire charge sheet with you?
I don't have the copy, my lord. I'm sorry to say that, my lord, I'm not in the office as of now because I have some medical emergency.
So
And
then, Mr.
they have sent the registry
Sir,
was
you have not supplied the entire charge sheet to the office of the PP? Mr. Okam, can you hear this court?
Lordship, it is, I cannot hear, Lordship.
Have you not supplied the entire copy of the charge sheet to the office of the public prosecutor?
Yes, from
was
the
direction
High
this
Court
court?
registry, they have the send this PDF to the public prosecutor.
No, it appears that MS Mary does not have the entire charge sheet today. So I'm posting this matter on another date. Please check and ensure that the public prosecutor has the entire copy of the charge sheet. When do you want
Lordship,
it? It's an NDPS
Lordship.
matter. I cannot proceed unless all the papers are handed over to the office of the PP. Yes, when do you want it?
My lord, if
Lordship, I cannot hear.
When can you have this matter? Mary?
my lord, tomorrow, anytime. Tomorrow.
Day after tomorrow, Wednesday. In
Yes,
the
my-
meantime, you get hold of the charge sheet.
I'm deeply obliged, my lord.
List this matter again through VC mode on Wednesday. Give the date. All right.
I'm deeply obliged, my lord.
All right. Yes.
I think it tomorrow TV.
Day after tomorrow.
Adultery dispute.
Yes, ma'am.
What happened?
Wait, I couldn't hear.
That an adultery marital dispute arose between the petitioner and respondent number 8. Respondent number 8 filed a complaint against me in the office of Circle Officer Chetan Circle.
You are the?
I am the petitioner.
You are the husband?
No. Why?
Why?
Thereafter, Your Honor, Circle Officer passed the order, entry order on the letter.
So complaint was filed by the husband.
Husband. Thereafter,
Husband is
respondent number 8.
respondent number 8
Yes, ma'am.
is the husband.
Yes.
It's Srimati, it's written.
So, number 8. In Paksa Raj. In Paksa Raj.
Petitioner is Yade Doni Raji.
Yes.
Yes. Respondent number 8.
Respondent number 8, husband.
Here in my copy it is 9. Pakshas Raji.
Mine. 8.
I don't know. In the court's copy it is 9. Why is this change in the court's copy? Who has made the changes? How many total? How many respondents?
8 euros.
There is another one.
Mine was 8.
The court copy doesn't tell you with your copies. Please verify. List this matter tomorrow. In the meantime, you verify what has happened. How come the court copy there is one additional respondent? Verify, and anything is to be done, do it by tomorrow. List the matter again tomorrow. Yes.
Wait, please, Lord.
Yes.
My lord had a query on the last occasion as to how the appellant was, if there wasn't any amendment, application for amendment for making the pro forma respondent as a respondent. There is no application, my lord. It appears the learned edition is just Pasigat, that by mistake written respondent defendant number 2.
How can that be done?
It appears there is a mistake because all along, in every proceedings, my lord, there was various proceedings, all along it has been maybe because the main contest was between the pro forma respondent and the plaintiff, that is me. In any case, a decree is binding on everybody, my lord, be it the pro forma respondent also.
No, but how the pro forma respondent earlier was respondent?
Yes, the contest was, though it was mentioned as pro forma respondent, the whole suit was contested between the
Because then in that
plaintiff and the.
situation, how can it be a pro forma? It should have been a respondent,
Should have
right?
been, should have been, should have been.
So how were they converted as pro
It was
forma?
not converted, they appears mistakenly it has been written as defendant.
No, nobody pointed out this mistake?
Should have.
Because that is a.
Because the judgment was
vital
reserved.
mistake, it has some bearing, because there is a difference as respondent and pro forma. The moment the pro forma is
No, my
added,
lord,
it means that you are not seeking any relief against that.
no,
person.
we are seeking relief against the former respondent also. And
That's
there's-
right,
there's-
therefore it ought not have been pro forma.
Should not have, should not have. But it was contested all along by the former respondent.
Anyway, I've forgotten this matter. What was it? What was challenged here?
That, it's a very old thing. I think prior to the father, the appearance is a son-in-law of the original land of the Procedural. And he purchased and property land. And thereafter, on death of the Procedural, the brother-in-law of the appearance the following year. So then thereafter, the 1991, 92, there was a cover decision, the cover decision came in favor of that. And in the meantime, the respondent here, the plaintiff in the crisis suit, they filed a press before the Justice Commission, and it was transferred. Without actually keeping, it was transferred to the Basar district court. There is a jurisdiction that in terms of big Mohammed judgment that FTC was constituted. So then what has happened? Then again that there was a proper adjudication of it. Then it went in their favor. Then the appeal made across this Honorable High Court. That is Honorable High Court was satisfied. The judgment and decree of the court Basar.
By which that Kabang decision was set aside.
Then being agreed by the decision of this Honorable High Court, the respondent and closed appeals. The apex court
Remanded it back.
Set aside everything and Basar title suit was remanded. That's the summary substance of. Now, the issue that I have raised, which my learned colleague, Mr. Pandyan, has given the clarification. The answer, my lord, you find at page 74.
74.
Of the paper.
Yes.
Go down to page line 46.
Yes, we're starting.
It's from top to the.
No, read the sentence.
The plaintiff,
Hmm.
the plaintiff, being agreed. While he present appraised to ventilate, the fact will be issued with appraised to treat the same as appraised case or appeal against the Kabang. And accordingly, the deputy commissioner passes that admitted the appeal and directed the respondents to apply the way to appear and to find a statement on 11/6/1993 by his order number so and in compliance of which and in compliance of which the respondent filed his first written statement on 11/6/1993 where he proposed admitting the plaintiff's claim in respect of the dispute ban and based on which the plaintiff sought for an appropriate decree. But the deputy commissioner, instead of passing any decree order for treatment of the present proforma defendant in the state suit, as such was showing this is patently illegal. That is the finding, although this judgment decree has been one set aside, but in terms of section 41 and 43 of the Indian Act, this is illegal.
This is
illegal. It says, without passing any order, the proforma defendant
has been impeded.
And through, it is in the
that which is reflected in the accused judgment and the first procedural aspect. But can we hang on to page 74 only? Now, the second portion of law that I am arguing, second lead, only on these two aspects I am arguing. The rest I will not even make any further submissions. Now, therefore, in the first case, therefore, that all the 6 rule 70 was not compliant. Therefore, on this count page, the instant judgment review, judgment and decree should be carried and remand the matter there.
What was not compliant?
That all the 6 rule 70.
Yes.
I'll place one judgment on this at a point of time. Just I will indicate the time. Now, the second theme of my argument on the procedural error committed by the Lagat court below, my point from here itself, can you come to the bottom of this paragraph? I read from here. And the deputy commissioner, as such, later on after hearing the parties, framed as many as 29 issues in the whole. Why is order dated so and so? These are there.
Yes.
Can you come to page 75?
Page?
75.
75. Yes.
Now these are the 29 issues.
Yes.
Now what is more pertinent to be noted here is that after last line, after framing of issues, the plaintiff examined 3 PWs, and after closure of the plaintiff's evidence, the defendant and former defendant examined 4 PWs in totality. Now, from here, my lord, we infer that the trial has already commenced. Meaning thereby, Lord, you cannot proceed with the trial.
Yes.
Proceed with the trial without filing an amendment application, making the proforma defendant as an original party, necessary party. And my lord, we find that in order of rule 9 and 10 of the series, joiner and rejoiner of the parties.
Yes.
So that means, the objective of all the 6, rule 17 and 18 is very clear. Other than my lord made a note on this. Then I made an argument. Now the second theme of argument that I am advancing is, the Lagat court has heard dissecting the plain party, which is not permissible in law. That should be a blanket violation of Order 40 Rule 5. As Melon has seen already, in 75.
Yes, 29.
75, 75, and 76.
Yes.
Now, can you see? In the impugn judgment, I will demonstrate from here. Kindly come to Para 7 at page 27 of the impugn judgment.
Page?
Please, Para 7, page 28.
28.
Yes.
Yes.
Up to here, on the day also. Now, can you see Para 7? That during pendency of this suit, before the court of Lagat Deputy Commissioner, the Lagat Deputy Commissioner passing a friend as many as 29 issues for determination of which each are as follows. Now these are the 29 issues. Manor will see kind of issue number 4. For a moment. This is an issue that has been framed with the consent of the parties. Very important to decide. Then can we see issue number 6, 7, 10, and 12. Now, Para 8 is more important. The this on the issue, on the issue. Now, look, there are 40 below, page 21, 32. Here, below, the largest trial court have only decided 11 issues out of 20, which is patently illegal. And you cannot. Framing of the issue is a part of the strict procedural aspect in the CPC law.
So they picked up only 11 issues for determination out of 29. Is that permissible?
Not permissible. The answer was not pending from there are 40 for a book.
Out of the 29 issues which were framed earlier by the DC,
DC as well as
by the Court of District Commissioner.
court also.
Yes,
Now your pending comes to page 31.
yes.
And this court, there are 40. And this court, having gone through the proceedings of the instance and also keeping in view the Honorable Supreme Court's order, whereby the Honorable Court, after setting aside both the aforementioned seven petitions and orders of the Deputy Commissioner directed the Deputy Government to not to take free of the Divikata, I find it necessary to discuss entire issues framed earlier by the Deputy Commissioner and therefore this court out of 29 issues framed by the Deputy Commissioner pick up following issues. How this is permissible?
That Supreme Court, where is the apex court's order?
I have placed other things.
Yes.
They have revived this Basal title suit.
Yes. There is no bar, there is nothing. The entire case is directed to be revived and decided afresh after considering the evidence. Correct?
Even for that, the consent of the party or the court had the power to direct both of them to file the application for settlement of the issues. Here is a case where the Malaysian court has not excised that particular aspect of the question.
All right.
Now, on these two issues, first, I argue my brother satisfies that.
You'll have to give us give this court a short written note of the arguments and the relevant points. Yes, Mr. Pengi.
Well, I will place those judgments in the written argument.
Just two things have been argued. One about the impediment and the second about out of 29 picked up only 11 issues. If that is permissible when the entire suit was remanded back.
The page 78, that order that was being read by my learned friend,
Yes.
was in respect of title suit number 41, 2006, that was interfered with.
Title suit?
Number 41, 2006.
Yes, number
41,
41 of
2006.
this is the apex court decision is in respect of.
Yes, this was interfered.
Yes.
My lord, will kindly have page 74 again. My lord, will kindly consider this suit was filed before the Deputy Commissioner, not before the regular court. And powers to exercise civil jurisdiction to the Deputy Commissioner was conferred by the 1945 Assam Frontier 1945 regulation. CPC was to be followed only on spirit, not in letter. That was the whole purpose.
Regulation is applicable.
Assam Frontier Administration of Justice Regulation 1945. Only the spirit of CPC was to be followed and not the mandate. There's a reason behind it. Because the deputy commissioners are not trained judicial officers. And in terms of the 1945 regulation, the village authorities were conferred with the civil powers as well as the deputy commissioners. They will be conferred criminal powers also. Now, because there were no regular courts, and at that point of time, there were no judicial officers here. That is why the whole purpose of 1945 regulation was that only the spirit of CPC will have to be followed. Now, in fact, the earlier suit was withdrawn. Subsequent suit was filed. This has been wrongly reflected. Your Lordship may kindly have page 1.
Page 1?
Yes, of the paper book.
Of the paper book?
Yes.
Yes.
It was refiled after withdrawal.
Title suit 3 of
1993. Here the appellant was arraigned as a pro forma defendant number 2. It was there in original petition. He contested, never raised these questions at any point of time, neither before the deputy commissioner, neither before the fast track court at Basar, neither before the High Court initially, and neither before the Honorable Apex Court. Honorable Apex Court, having seen the manner in which the proceedings have been held, set aside each and every order. He remanded back the matter to the district judge for trial. And that is how this judgment and decree has been passed. What had happened, my lord, was, I will just give that list of dates. Initially, the first kabang was held on 19/12/1991 in favor of the appellant. 23/5/1992, another kabang decision in favor of the appellant. Against, that was in fact confirmed by the order of the deputy commissioner, by order dated 4/2/1993. All these kabang decisions, confirmed by the deputy commissioner. We filed the title suit before the deputy commissioner. All sorts of minor procedural errors are there. The defendant number 1, in fact, filed 4 written statements. Ultimately, 1 statement was accepted. That is how it went to trial. Now, ultimately, the evidence was completed before the learned deputy commissioner, but it did not pronounce any judgment or decree. Ultimately, it was transferred over to FTC Basar. So, by 30/4/2007, title suit was allowed in our favor. Against that, they came before the Honorable High Court, saying that since the kabang has already decided that the title suit could not have lied, res judicata, and that is how it was allowed. We challenged it before the Honorable Apex Court. Honorable Apex Court, seeing the manner in which all these proceedings were done, set aside each and every order, kabang decision, these 2 kabang decisions, the order of the Deputy Commissioner 4/2/1993, the order of the learned.
Where is that decision of the Apex Court?
Yes, that is there, my lord. The same judgment, my lord. Your lordship is having.
Here they have not set us.
Yes, everything, my lord. My lord will kindly have the page number 1 of the.
Yes.
I will just provide you a copy, my copy.
It's the same one. It is civil appeal number 1022
Yes, yes.
of 2010.
Yes. May I read, madam?
Order dated 2nd December.
Yes, madam.
Yes. Read.
Leave granted. We have heard the learned counsel for the parties. We have also perused the impugned judgment dated 1/8/2008 passed by the Guwahati High Court in MFA number 2 of 2007. Judgment and order dated 30/4/2007 passed by the fast track court. Basar in title suit number 41 of 2006. Orders dated 24.
All right. Yes, you're right.
Everything has been satisfied.
But set aside and the matter is remanded to the Deputy Commissioner Pasida.
Everything has been satisfied.
Decide after. All right.
And regarding this issue, my lord will see what the issues were before the Learned Deputy Commissioner. Page 28.
Yes.
First one is whether the case is maintainable in its present form and as per law. Whether the kabang decisions of 1991 and 92 were agreed by the defendant. Now, all these things were already interfered with by the Honorable Supreme Court. And these are the issues that are there. My lord will see all these other issues, 29 issues, not at all relevant. That is why the Learned Additional District Judge only picked up the issues that were relevant. And he has that power to strike off the issues that are not relevant. Order 14, Rule 5. After the interference by the Honorable Supreme Court of these kabang decisions, these issues regarding whether these kabang decisions were in favor of this and that, all these are no longer any issue. Order 14, Rule 5. Power to amend and strike out issues. That is how. So, my lord, the first submission, my lord, CPC is only in spirit. In fact, another trial issue was for after withdrawal, where he was made a pro forma respondent. And that is how iteration was filed against that, contested all along up to the Supreme Court. All these issues never raised. So that answers these two arguments that my learned friend.
Yes. So these two Kabang decisions have also been interpreted.
Yes. So where the question of these issues remaining
So
alive.
therefore, you're right. Therefore, this issue is,
Yes.
according to you, not only. But what about the other issues?
The main
There
issues,
are- there are
have been
29.
main issues have been taken up. All the issues that are relevant for the purpose of determination of the
No,
truth.
but you see, even assuming, for the sake of argument, that the deputy commissioner has the power to take the relevant issue, there has to be some order, there has to be some application of mind, there has to be some reasoning, which has to be seen from the order.
My lord will
That is
kind.
not there.
My lord
It
will.
simply says, in page 78, I believe.
No, my lord, page 31.
No, that.
74 has been interfered with. Page 31, my lord. This is the judgment and decree that is under challenge.
Page
31.
31.
Yes.
Where is that? No, at
Paragraph
least
14.
32.
32.
Kindly come to 32.
Yes. But before that, my lord, will kindly have paragraph 14.
Maybe you're right. You read, please,
Paragraph 14.
read 14.
And this court, having gone through the pleadings of the instant suit and also keeping in view the Honorable Supreme Court's order, wherever the Honorable Court, after setting aside both the aforementioned Kabang decisions and orders of the Deputy Commissioner, directed the defendant number 2 not to take the plea of res judicata, I find it not necessary to discuss entire issues framed earlier by the learned Deputy Commissioner, and therefore this court, out of 29 issues framed by the learned Deputy Commissioner, pick up the
But
following
what does
issues.
it mean not to take plea of res judicata?
That was because before the Honorable High Court, in MFA 1, just a moment, my lord. Yes, MFA 02 of 2007. The ground on which the order passed by the learned FTC was challenged was that the village authority had already decided the matter. He has the parallel jurisdiction in terms of civil
But
procedure.
now because it has been interfered,
Yes.
therefore res judicata will not
Yes,
come.
yes.
That is one.
The High Court interfered because of res
decisions have
judicata.
already gone
Yes,
now.
everything is gone.
So the Kabang decisions are no longer holding the field of law.
Nothing is.
Isn't it?
Yes.
So afresh, the whole
Yes.
issue has to be decided. Okay,
Yes.
all right. Yes, anything in reply, or you want to cover it in your written argument?
In my.
All right. So, when would even you
But,
file a small?
but my lord, this is the first appeal. Ultimately, if your lordship has to decide it on marriage, then the evidence will have to be read, my lord.
If they are not giving it, we cannot force them.
If my learned friend is not arguing, then I will take your lordship to the evidences.
Yes.
Be careful.
No, then, see, it is now, if it is only to this, he has only argued
Well,
in respect of picking up the 29, out of 29, picking up 11 issues. This is what has been argued.
Yes.
Which against which you have given a reply, right? Now, we can confine it to those two arguments, if that is what the appellant wants.
my lord, this is the first appeal, I understand.
Yes, but for deciding this issue, there is.
Before
certain-
entering into the merits, my lord would like to decide this issue first.
Exactly,
In
because
this
this is what has been raised before this court. In his argument, he said only two issues he wants to raise. Number one, impleadment part. Number two,
But my
out of
lord,
29.
this being a regular first issue, these issues along with the merit will have to be argued, my lord.
But if the appellant chooses to only argue this, then I will confine my decision also on that.
But I
And
will
of
have to
course,
address your lordship
You have already addressed on these two.
on
issues.
these two.
On merit, he has not
Yes.
gone.
I will have to reply on merit also, but I will have to.
But if they are not going into the merit, then
This is
it
a
is
peculiar
necessary for
situation.
this court to go into it then.
Then in the event my lord does not accept my learned friends these two issues, then the my lord decree will have to be upheld. In this case, my lord, I will give written argument.
That will be in your favor.
Yeah. I will give written argument on the positions also.
We do it like this. I am posting this matter on Thursday. Can you provide the written arguments on Thursday?
Yes.
All right. On Thursday, we shall see how to proceed there.
I'll say both of us will come with the written argument. And
Parties
the
to
biggest thing
submit-
is, my lord, these two arguments that are ours are not even the grounds of appeal.
Anyway, you take your point.
I have already mentioned this appeal.
Very well. You take your, Mr. Banking, there, you take all the objections you want to take. You're at liberty to take. Councils to file respective written arguments, list this matter on Thursday.
Okay.
Yes, Mr. Das? What is this petition? Okay, Santosh. Itu your Agor case to. Really broken Agor. Okay, na? Raju.
My lord, I am extremely sorry. Interim order was there.
In the earlier matter, interim if any shall continue till the next day.
Very good.
Two notifications say, under the new act, it is under 41. 40(1), on the right to fair communication.
13.
13. So 41 says that it is the urgent purpose, and the appropriate government has to digest the respective government to acted as a different purpose or any other purpose. So according to notification issued in short, notification was issued under 41 to take over it, and accordingly, under section 21, it was notified to all the landowners.
It was notified.
Notified to all the landowners, and in respect of 41, there is no question of any award, there is no question of any objection. It is once
You are for the,
41.
you are appearing for?
I am appearing for the petitioners.
No, who are the petitioners? Landowners.
The landowners. The landowners. It is represented by where the power is given to all the landowners. So I am appearing for all the landowners.
Right to Fair Compensation Act 2013. Right to Fair Compensation Act 2013, correct? Give me that direct and give me the papers.
There was an order, just to point out, there was an order for the MSC. There was a 2019, 26/9/2019.
19. Yes, I've got it.
That order says that within a period of 3 weeks, the compensation has to be 3 months, the amount has to be paid. But this was challenged by people in division bench. When
Just one sec, Mr. Das. What happened? Notice is under section 40?
41, 40(1).
40(1).
Right to fair compensation, land acquisition, re-education, reassessment Act 2013.
All right.
There are 3 notifications, 2 notifications under 41 and 1 notification under 10 of the Balipara.
Under 10 of
Of the Balipara.
Balipara Act. You have a copy of this? Marissa?
I think put name is the sale.
Balipara Act is there?
Balipara, Tirap, Sadia, Frontier Tract, June Land, Regulation 1947.
Is it there in that regulation?
We have annexed this all this, but you are
Let me have the, at least
that is
the,
very important.
one is the 13 Act and there is an Urgency Act.
One is, yes, right to fair, confidential transparency in land acquisition, rehabilitation, resettlement and.
That 13 is taken note of.
And this kindly look into it.
Acha, you are referring to the Assam Northeast Frontier, Sadia, Balipara, Tirap and Lakhimpur tracts electric regulation? No.
No, this is.
Just give it to me. Mr. Fukan, kindly look into it. If it's part of this, otherwise you may.
Page 73, I think, 73. If it is same, I don't know, the same. Same.
73, just see page 73.
73.
The Balipara Tirap Sadia Frontier Tract Jumeland Regulation 1947. And where do I get the Urgency Act?
Urgency, not here. Here it is not happening. That's why I mentioned it. There are three notification. Two notifications under the Act 2013. One is under Section 10 of this Act.
Okay. Section 10.
Why not we kindly see for a moment before going into the procession of the into the nicety of the entire case? See, kindly see the 2013. Then I think it will be
yes
here. 2013. See Section 40.
Yes, I have it.
Yes. Special powers.
Yes.
In case of urgency to acquire land in certain areas.
Yes.
Now see the word. In cases of
Urgency.
Whenever the appropriate government so directs, the collector, though no such award has been made, may, on the expiration of 30 days from the publication of the notice mentioned in Section 21, take possession of any land needed for a public purpose, and such land sell thereupon rest absolutely in the government free from all the income taxes. This is 41 it says. Now the question here is the appropriate government. What you will see, is the appropriate government. Appropriate government is the central government. They want. But that direction has to be given to the collector. See the word. Whenever the appropriate government so directs.
So the appropriate government has to give direction to the jurisdictional deputy commissioner.
That's what has been given. That's what a notification has been issued by the district collector in so far acquiring the land under Section 40. So now, very interesting point, I think my lord has not taken anywhere either before a single bill or before a division bill. It is a very important section, which I am trying to my learned friend, we may have really shown me. Kindly see 43.
Before taking possession.
Before taking possession of any land under subsection 1 or subsection 2, collector shall tender payment of
80% of the compensation.
This is what? Now,
so there is a precondition.
Yes, the precondition. Why? If you take a land for artistic purpose, now I asked my relative here, where is that area? It is Anjar. That's a China border. So there is one more case I have been told in the Supreme Court also. They were acquiring, they were under these agreements. But they said the depository money and some money has also been taken as given to the landowners. But here is a case where no amount has been deposited only. But these are border areas. So once it is notified, urgency basis, there is no award, there is no question of award. You have immediately have to hand over to it. So now these are all here we are calculating. The reason behind to register this law 43, what I understand was that you immediately compensate before taking out money because you stop cultivation. There is no question. So you have to make 80%. So that right to livelihood, that's the real intention.
Is not affected.
Why this particular fee? I was just looking why this fee before taking possession of any land. Here, my lord, the position was taken, but before taking possession.
In your case, compensation was not given.
Not a single one. Well, the largest single
And when was this taken?
is somewhere in 2017.
Till now you have
No,
not.
not a single penny. 2017.
This is a writ you have filed.
This is a writ we have filed. So this is neither this is one of pointed out. 43 was never. I checked all the orders and 43 was not pointed out.
To this
When
point,
it's
you
like
have
a
not.
normal, it's like a normal award. Where is the notice? There is no question of any notice when it is required for RBC purpose.
Because these are special
These are
circumstances.
the special circumstances. So their intention is to 43. Before taking possession, you have to pay. So they
All right.
they have to look at somewhere. Now, one of the kindly see 21 kindly see now. See 21. These two sections I am taking it so that it will be easier to.
Yes, yes, of course. 21.
21. See 21. Notice to personal interest.
Yes. Yes, please.
The collector shall publish the public notice on the website and cause public notice to be given at convenience basis on or near the land to be taken, stating that a governing interest to take possession of the land and that claims to compensation, reapplications, resettlement for all interest in such land may be made. Now these are procedure which has been laid down. Now this is in terms of section 41, subclause 1. Now these are the procedure which has been laid down. Two, the public.
How are you linking this to section 40?
No, why? Yes, my lord will kindly see. My lord will kindly see. See it. After expiry of 30 days.
Where are you reading, Mr. Das?
41.
Okay.
41,
Yes, yes, yes.
C41.
Yes.
In case of urgency, wherever the appropriate government so direct.
Oh, it is mentioned here. It's mentioned here. From the publication of notice mentioned in section 21.
So that's why I'm in section 21. Now I have to show that whether there was really notification under 41. So this is the section. So see, my lord.
Is your case that this notice is also not issued?
Notice issued.
Notice issued.
Everything. That's why I'm showing.
That is as per 21.
Everything.
Only thing, the compensation is not given,
Compensation is not.
which is also a prerequisite.
Now let me put it very frankly. Why division? You also should know it. Why division means set aside spends back. After the matter before the single bench, we went for division in somewhere in 2021. The Union of India West. And the first time they raised it, where is the sanction? We have, in principle, we have approval, but there is no sanction. There is no sanction. There is no sanction. So now we understand in the state, but because they have come out. So the argument which is by the respondent, the Union of India said it is too late a date, where in 2017, 15 one notification, 17 another notification, now you are talking about sanction. But whatever maybe it was sent back to the seniors are to decide the issue. That is why it came up before, it has come up before this court. Now my argument before opening of the file is if you are given under 41 and you comply with section 21 and the fact also by notices and you have taken possession, you have taken possession, we are displaced. So where no comparison. So you pay 80%, you deposit the 80% of the amount at least because by virtue of the statute we get 43. Where is that? This was, I'm so sorry to that it was not mentioned. 43 we are entitled as 80%. And
43?
43. Surplus we are entitled. And I have seen some judgment before opening, that's very important. One of the judgment of the Supreme Court, it says, I brought that, it is not that we cannot reverse back in my hand. Not that, like others, the compensation is not complete, you reverse back, that also doesn't happen. Now you will also kindly note 43 is a parameter clause of 17 of the order. Kindly see 17 of the order. Because that's what reference before 3 judges bench of the Supreme. Kindly see 17. Because I think this documents have been shown.
LA Act.
LA Act. See kindly see 17 of the LA Act.
Yes, yes. Yes.
Now see, special found in case of urgency. Please compare with this. In case of urgency, whenever the appropriate government so directs, the collector, though no such award has been made on expiration of 15 days. Here is 30 days. That's the difference. The new act is 30 days, here is 15 days. From the publication of the notice mentioned in section 9. Now section 9 is again go back to section 21. If you see section 9.
Section 9 is, all right, it's okay.
Yes, this is
The procedure of notice. Procedure of notice is given.
So now take possession of any land needed for public purpose. Such land says thereupon rest absolutely the government free from all income. So this was there. So that is why maybe a huge voluminous is before this court. Maybe you may raise lot of points in the future. End of the day is 41. You don't deny that 41 is never served. You forget about that.
Under the old act, that compensation clause was, subsection was not there.
Which one?
Subsection 3 of 40.
43. That is, if you see.
Anyway, it's all right.
40 of the old act, 48, which speaks only of compensation. But the land is never reversible. Once you, whatever you have done.
What is the prayer in this way?
To pay compensation,
But why is this compensation not being paid, Mr. Counsel? Why, when the provision of the act prima facie manifestly clears that before taking possession, the compensation has to be paid 80%? No, but this, I'm sure, sorry, I will hear you all at length, but it appears that subsection 3 of section 40 has not been complied.
My lord.
Is that a correct position?
My lord, it seems, my lord, as per the affidavit filed by Deputy Commissioner, I'm sorry, it's additional Deputy Commissioner. It seems, my lord, process is there prior to that, 2012, my lord, whereas Lara Act is 2013, my lord. But anyway, my lord, the affidavit filed by the department, the district administration, they have not denied, my lord.
Not denied what?
Denied, my lord, land had been possessed, it is given to the.
Under the provisions of the 13 Act? 13 Act is applicable?
My lord, it start from 2012.
No,
But
my specific question is this this land has been acquired under the provision of section 40 of the 13 Act, correct?
Correct.
Notices has been issued
My lord.
under the section 40 of 13 Act. This is an admitted position?
My lord.
Is it
Now, my
admitted?
lord, now, my lord, if the amount is not paid, obviously, my lord, the 2013 will be made applicable. My lord. If the compensation amount is not paid to the landowners, my lord, obviously, my lord, the 2013 will be applicable, my lord. But here's the question, my lord. The entire, my lord, joint survey, everything, my lord, land position, it was surveyed, it was taken position from the village, and it was handed over to the defense, my lord. My lord, now, my lord, at that relevant point of time, no one raised about the 80%, my lord, as per the section 41 of the Lara Act 2013, that 80% should be deposited. Perhaps that provision was no one, my lord, strike in their mind, my lord, that 80% should have been deposited prior to, my lord, land is taken
Mr.
possession, my
Counsel, if
lord.
a provision of law has not been raised by the landowner,
My lord.
is it your case that that provision would become infractious?
No, my,
It
I'm
is
not saying that.
It is a provision of law, it has to be respected.
My lord, I'm not saying that.
Procedure has been laid down under section 40.
Now, my lord, ultimately, my lord, land had been, my lord, acquired, then estimate has been met, and it has been sent to the, my lord, central government. So once the central
When
government,
can the compensation be given?
I'm sorry, my lord,
When can the compensation be
the
given?
moment the central government give us, my lord, we can release.
Sir, who is appearing for central
Central
government?
government, my lord.
Anybody for central government? Yes, why is this not been released?
Malad, in this case, earlier round of writ petitions, Malad, I was the counsel for the Malad.
Please first answer this question that is put to you, because you see it's subsection 3 of section 40 mandates that before taking possession, 80% of the compensation has been paid, correct? Now, if that is the object of the act, that has to be done. here is a case where the land of the petitioner has been acquired and till date, no compensation has been given. You have already taken the land, possession has been taken. But why this compensation as per the act is not being released till now?
Admittedly, as per the affidavit filed by the Union of India, it is transpires that the principal in approval is not done at the relevant point of time.
Then how the land was taken?
That is the one
So,
aspect.
see, if the land has been taken, then compensation has to be
Yes.
given.
Yes, admittedly, the procedural mistake has been taken place.
That
Malad,
is,
the land was taken
the
first.
court is not concerned with that. The landowners, the affected parties have a right under section 40.
Local military authority, they took over the position of the land. By that time, the no principal in approval was taken and granted by them, the Chamantri. That is the one of the core issue. Admittedly, I read round of petition, I was the counsel. After the matter was went to the division, honorable division bench, after remanding the matter, the other colleague, they appeared. So, at this stage also, it is very difficult for me to make the correct position of the correct facts of the case. That early round of petitions, the one Mr. Doloi, he was handling the case,
Mr. Das, at which page the prayer is there?
My prayer is kindly see at page 24. Page 24. In the premises where it shows, maintenance to direct the response of 125 and will to pay compensation of 125.
Anyone has assessed this compensation amount?
Yes.
Where is that?
How it has been assessed?
Yes, because it appears that the respondents are not in the interest of making this compensation. In that case, we shall hear the matter and direct. Because approval, non-approval, these are your internal things. Page?
89. It starts from 89. 89, all calculation has been made. Amount also, reasonable time is bottom.
And these assessments were done prior to possession or after?
This is 9th of May 2017. And the notification was issued in 20th of July 2017. All before.
That notification 20
July 2017.
20717.
20 July 2017. 11th notification is 11th of October 2017. And another notification is 13 November.
All right. So this amount is 89 is assessed by the additional DC's office.
Yes. Can you see? 1,225, that's what our prayer was.
Yes.
300 rupees per square feet. That's the assessment that they made.
And in their affidavit, there's 10.
I think government is not denying.
No, they're not denying. Only thing is that they are saying that some sanction approval is required and all that. But in that case, they could not have taken possession.
That's the key.
In that case, they should have waited.
Yes, that's right.
That illegality has been done.
Why this possession was taken? Don't take the possession.
No, possession is taken because of the urgency. Otherwise, the very purpose of the section will become redundant.
My lord, here, my lord, the central government saw the urgency as per section 41, my lord. Then land was acquired for the different purpose, my lord. So that task was given to the district administration. So we have acquired and we have given to them.
Yes,
That part
but
we
in
have
that
exercised.
situation, before acquiring the compensation has to be given.
Yes, that part was missing. my lord.
That
part was missing. my lord.
inadvertently not done or what I don't know, but it appears it has not been done.
My lord.
So in that case, the landowners are being affected.
Yes.
You have taken their land. Before that, they were cultivators.
So-
These are very poor
They are paddy cultivators.
My
The land has been taken, no
Yes.
compensation. 17, it was taken till now.
So-
We are in 24. Mandate of the act is before possession.
Yes, ma'am. 2017 itself, madam, assessment was done. It was
What
there
is to be
get that.
done then?
Can I just suggest?
Yes.
To your lordship what it says. This mandate of, this apparently I have shown that there is a notice on the 41. 21 complies, it is a fact that possession has been taken. Even 17, where 43 says before taking possession, 80%. So let the central government deposit that 80%. And let further hearing takes place. But at least that 80% should be deposited. It's a mandate of law. Minor is not, it's a mandate of law. It's nothing that your lordship is doing something which is not, it is under the law. Let 80% be deposited.
Where is the union's affidavit?
The two affidavit has been filed by the affidavit filed by the minor 1 to 4 on minor.
My lord, can I show one affidavit? What is destined now? Reversing entire 2000. That is affidavit filed by government 1 to 4. Page 29. Can you see? Lordship got it?
Page 20?
29.
Page 29.
29. The affidavit filed by the Union of India. What is for 1 to 4?
Filed on 30th January 2019.
See, can you see that affidavit?
Affidavit in opposition by 8 and 9?
1 to 4.
1. That is not there. Yeah, the affidavits are not marked properly. That is the problem. You have a copy?
I have.
Filed
by
1
the
to
Union
4.
of India. See kindly at page 29. 29. See the date.
Yes.
See the 23rd of July.
Yes.
This is some officer in Defense Estate.
Hmm.
Refer to so and so. It is submitted a joint survey of 177.66 acres out of 200 acres land in following area under so and so completed on 10th of January 2007. My lord, we kindly see they admitted. The above mentioned joint survey carried out consider prevailing a log requirement of Dawadela Valley and then available infrastructure including surface communication with consist of a single road with port surfacing between so and foot movement till so and so. However, it has been reliably known road so and so is being improved by BRTF, which will facilitate smooth movement. In addition, a road with so and so is planned to be construction by so and so connecting so and so with this. Therefore, earlier requirement to acquire land will not be required to be pursued. In 2018, see my lord, how the fresh
So what does
requirement of
that
land.
mean? That 17 that your land is not required.
They now saying it is not required. Now what they say, a fresh requirement land has been work of keeping in mind operational requirement in future. These land pockets are as under.
Land cannot be reversed back.
That's the whole case.
You'll have to file proper affidavit and explain.
I will kindly see that subsequent to this notice 41. This is 2017. Kindly see my note. All has been done. Kindly see my writ petition. See the writ petition, my note. See the
Which is the annexure from where one can find that the possession was taken?
Yes, I'll show you. See my note at page 11. See from 99. This is a notification which has been issued. Now, my lord will kindly see these are notifications. First notification, kindly see 28th of July.
Yes, yes,
99.
yes, I have it.
And this is under 41. Kindly
Yes,
see
yes.
41 of the right to so and so, power and function so and so. So these are the schedule of description, specification of land. Total around I calculate 130 acres it is. If you class it, it will somewhere 130.
Under this notice, it is said that it is required for urgent purpose,
Yes.
right?
Right.
And after that possession was taken when?
So now my lord will I just show the section 21. This is at page 116. See 116. Because it is for general information to all landowners of so and so The government of Arunachal issued gazette notification dated 20th of July 2007 under provision of section 41 and transferring land acquisition of land under urgency clause, urgency clause for acquisition of land as schedule given below for establishment of defense outpost to meet up the requirement. For establishment of defense outpost to meet up the requirements
Yes.
of Indian Army at so and so. Therefore, kindly see the word. Therefore, all the landowners at case 21.
Yes.
See, it is for general information.
To stop all kind of activity. I've seen.
All kinds of activities. 120, kindly see, 120. These are position notes. Kindly see 120. Your lordship is asking a query, where is that notice, that letter?
This one, 8917.
Yes. Kindly see the last, therefore, the second paragraph. Therefore, expiry of circular 45 takes all the land
Into possession.
Taken possession. Yes, clear cut. Today you are saying by letter, no, we don't want. What is that? You have taken possession of the government land. And kindly see the provision of the statute. Before taking possession, you deposit.
All right. So, I'm directing in the interim to deposit the 80% compensation in as per the mandate of subsection 3 of section 40. In the meantime, you all are directed to file additional affidavits to clarify your stand in the matter.
Just to,
No, and grave injustice has been done to these land affected, the landowners. You have taken their land and you have not paid them till now. 2017, you have taken their land. As per the mandate of the law, 80% of compensation ought to have been paid before issuing this possession order on 8/9/2017. This is absolutely illegal.
at that relevant point of time, there was some urgency.
Understood. Because of that urgency, legislature has enacted subsection 3 of section 40 to enable you to acquire a land if there is an urgency, but you have to do it in the manner prescribed. Najir Ahmed case, if a manner is prescribed, it has to be done in that manner. All other manners are forbidden in law. The Privy Council's decision, yes.
So, space is dishonorable for madam. Since today I am appearing, madam, and earlier Mr. Dolly was the council.
That this court is not concerned.
That way, madam.
Yes.
May I present, madam? My submission is, madam. Though my name may be.
See, it's all right. I'm not disposing of the petition matter now, but I am only directing that what is provided under subsection 3 has to be done. You can take your instructions. You can file affidavits later if you want and make arguments.
These are all affidavits are complete.
Yes, but he wants some time because he can take time. No problem. We'll give him time.
Yes, but 80% they deposit and let this matter be taken up.
Heard Mr. D. Das, Learned Senior Counsel, assisted by Mr. R.B. Fukan, Learned Counsel for the petitioners. Stop. Also heard Mr.
Well, I'm for respondent number 8 and 9, RH Nabam Baila.
Mr. So-and-so for respondent number
8 and 9.
8 and 9.
Yes.
And Mr.
Malan, I am for respondent number 125.
125.
Malan, I am appearing in absence of Madam Mr. D. Dolly.
What is this in absence? There is nothing called in absence. You're appearing, then you're appearing. Santosh, please take their names. Give it to Slow. It appears that the land of the petitioners were taken possession by an order dated 8/9/2017 pursuant to notification dated 27/2017.
Yes.
Issued under the provision of section 40, section 40 within bracket 1 of the Right to Fair Compensation and Transparency in Land Acquisition Act 2013.
Pre-notification.
Can you
That's the main one.
stop? It is admitted. It is submitted at bar that the aforesaid not aforesaid, that the said possession of the land of the petitioners were taken without making any compensation. Stop. A perusal of subsection 3 of section 40 indicates that before taking possession of any land under subsection 1 of section 40, the collector shall tender payment of 80% of the compensation for such land as estimated by him to the person interested entitled thereto. Mr. Das, learned senior counsel, draws the attention of this court to where is that to an assessment
Yes, assessment starts from 89.
made, yes, I've got it, to an assessment dated 9/7/2017 done by the circle office. This is done by the circle officer.
Yes, counter-side petition.
Done by the office of the deputy commissioner,
Yes.
whereby the compensation has been assessed in favor of the affected landowners, i.e. petitioners. Stop. It is an admitted position that the said compensation has not been paid till now. In fact, because of non-payment of the aforesaid compensation, the writ petition has been filed. Stop. Be that as it may, the mandate of law is absolutely clear that in cases of urgency under section 1 of section, under subsection 1 of section 40, the appropriate government can acquire land in exceptional cases, but before taking possession of such land, comma, the collector is obliged to tender payment of 80% of the compensation for such land. Stop. Admittedly, this has not been done. In view of the above, in the interim, it is provided that the respondent authorities shall make payment of 80% of the compensation assessed for the subject land in favor of the petitioners after due verification. Stop. The exercise shall be done within the landowners. The exercise shall be done within a period of 1 month from today. Anything? I'm giving 1 month time. Yes, you want to say something? Whoever has to pay. So I am. All right.
Let them file an affidavit to accept that the amount has been paid. No, state government. State government. It is state government.
No, he may be right. He's asking to notify the respondent who has to make the payment.
Yes.
So that will be respondent number?
Respondent number 1, 2.
No, central government.
Central government.
All right, I will say that. Just respondent number first. Where I have said Mashwai shall make the payment, you say the respondent numbers
1 to 4.
1 to 4 within bracket central government. Central government, Union of India shall deposit the amount to the state government, who shall thereafter release the same to the petitioner stroke landowners within a period of 1 month. Let the state government file an affidavit indicating compliance of the indicating the status of such payment.
Yes.
By the next date. Stop. List the matter after 3 weeks
Your lordship said 1 month.
So list
After 4 weeks, Mala, then it will come.
you can give a date after a month.
Lordship said 1 month.
After a month, you give a date.
April, May, June first week, any date? June, any date? You can choose from 3, 4 to 6. 3 is Monday. 3rd is Monday. So, my lord,
Fix on 3/6/2024. 3/6/2024.
That's the
election, perhaps result declaration. will be
Reason
done.
is in
So,
Adultery is second, I think.
second or third or fourth, I am curious.
Fourth is-
Fourth or fifth.
Third
4/6.
is better with then again election is right.
All right, 4/6.
4/6.
4/6/24. In
Fourth again, lordship, then
Can
we-
it be so many?
Anyway, you give the date. Mr. Fukan, you give the date to my private secretary. You give a date later on. Just give it. In between, I'm also adding because fairly councils, you have submitted that the mandate of law, there is no doubt about it. So I'll just add that paragraph. It is further submitted fairly on behalf of the respondents that there is no quarrel as regards the aforesaid mandate of subsection 3 of section 40 of the Act. Stop.
May I just, my lord, point out one thing, my lord.
No,
My lord, there are three requisition, but 3 notification. 2 is made under Lara Act 2030. 1 is Balipara Act 1947, where in Mara there is no such mandate, my lord.
So I am not saying
I'm just
anything.
pointing out.
Whatever you are entitled to do under subsection 3, you do that and you file an affidavit.
Central government will exercise, my lord.
Yeah, because this case is not getting disposed of. Any clarification?
Only my understanding is saying, before taking of the position, entire procedure was followed by.
You do one thing, you wait for some time. Once the order is typed, my court master will give it to you, have a look at it. All right.
Let me update. 8 I will just, here and there. I think second will be election here.
No problem. Ask Mr. Das, you just ask one of your junior to just give the date. Just, you all can go out, decide the date and give it. No problem. Yes, next matter. Transfer matter. Are you ready?
Yes, my lord, ready.
You want it to be transferred from matrimonial case?
Yes, my lord.
0 to UPIA.
Yes, my lord.
Why?
Because, my lord, I'm staying here and respondent also, my lord, he is also not staying at 0, my lord.
Respondent, you are agreeing?
No, lordship. That's why I filed the
You filed an objection. What is the ground for transfer that you have asked?
Because, my lord, I have unemployed, my lord. I can't afford this travel expenses, my lord.
You are what?
Unemployed, my lord.
Unemployed.
Yes, my lord. I have nothing to bear that expenses, my lord, from here to 0.
Any authorities in your support? Any authorities in your support?
No, my lord.
Because you see, transfer is not only for your comfort. It has to be convenience of all parties has to be same.
And my lord, my families are also here, my lord.
You are the complainant or you are the accused?
No,
You are the wife.
Yes, my lord.
And you are the husband.
Yes. And
What is your objection?
Objection, lordship. Number 1 point, because she stated to stay at Naharlagan. However, when the summon is issued from the concerned court, could not be served only for purpose of maintenance case. She took one room of rent. Thereafter, I think she almost left out, and she was not fine here. Number 2, your lordship, because marriage was solemnized at 0, not here. No territorial, no jurisdiction, this Papumbar. Thirdly, lordship, all the witnesses, because prior to filing of the matrimonial case, there was some dispute arises. All the witnesses who are signed as an agreement belong from 0 and also Daporijo. Daporijo is from here, I think, almost 300 kilometers away. And if 0 is the court, then it is nearer to for the witnesses and also the respondent to contest the case. That is my point, Lordship. Just I will show only one, that is the page 29 of my affidavit, Lordship. Annexure C, Lordship. This is the Lordship, what the order was passed by the learned district judge. That learned counsel, Mr. M. But appearing for the petitioner is present. Petitioner took steps on the respondent and filed postal receipt, but the notice was has been returned back to the court without service. Learned counsel, Mr. M. But take press step by hand. Prayer is allowed. Petitioner shall take steps by hand, dusty, and file a service report on or before the next day. Lordship. This is the how, and at that relevant time, Lordship, the maintenance case was proceeding in the UPA, and that was already disposed of, and I'm paying monthly 15,000 per month as a maintenance. There is no any issue now till now. We don't have any children, and now because of which address she has given in the maintenance case could not be served. So I personally, the learned counsel has served the copy to the learned counsel for the respondent, Lordship. Luckily, we have served. After receipt of
Where have you served?
in the courtroom itself.
And right now, the petitioner is residing where?
Petitioner is in Tirap district, Lordship. He is a
Petitioner is the wife.
Yes.
No. Oh, yes, Lordship.
Where is the petitioner residing? At UPA?
Itanagar.
At Itanagar?
Yes, my lord.
But
It is uncle's house.
earlier, the petitioner was residing at 0?
Nahalagan.
Naharlagan. No, this case was filed at 0 because the marriage took place at 0.
Yes, Lordship.
0 and Daporijo.
Two places, because we are the intercaste marriage, Lordship. That is inter-tribe marriage. So, petitioner is belong from the Upper Subansiri district, and the respondent is from the Lower Subansiri district. And marriage was solemnized at
Right,
0.
we shall take this case tomorrow for further hearing. In the meantime, you file a small note. Tomorrow or another date?
Tomorrow not possible for me.
When? Next week?
Next date. Written statement, my lord.
Next week, Lordship, that will be better. Either, no, day after tomorrow, we can fix day after tomorrow itself, Lordship. Tomorrow is 30, 21. Then, Lordship, yes, next week on Monday, on 6th.
List this matter on Monday for further hearing.
Yes.
Much
also.
Case records have been received. Yes.
Yes, I'm for appellant, Lordship. This apple, I've challenged your Lordship. The impugned judgment and award dated 4/6/2022 passed by the learned court below, Lordship, wherein the court below has made me liable to pay a sum of rupees 30 lakhs 40,000 to the claimant, Lordship. To the claimant, Lordship. And my argument is that, your Lordship, I'm not liable to pay, Lordship. The person, if any person is liable to pay, is the respondent number 2, who is a insurance company, Lordship. Because at the time of incident occurred, your Lordship.
The impugned order is at page?
Is at page
15.
No, Lordship. It's start from yes. It start from page number 15.
15?
Yes. So at the time of the
And,
incidents,
the
Lordship,
operating part is that page?
operating part is at page 27 and the 28 years.
Hmm?
27,
27.
yes, 27 and 28. Para 30 and para 31 years.
You are the
I'm the owner of the
vehicle.
vehicle.
You
Yes.
are the owner of the vehicle.
Yes, yes, Lord.
And you, according to you, you are not liable to make the
Yes,
payment.
exactly. Yes.
Why?
Because you say at the time of incidents, when the incident occurred, incident was occurred on 26/1/2014. Lordship. Uh, at the time of incident, the insurance, I have the active insurance with the insurance company, Lordship. Insurance policy, okay, to say the page number 54, Lordship. 54 years.
Page 54.
Yes, Lordship. At the time of incident, I was active. I was having an active policy, Lordship. With the respondent OP number 2, Lordship, who is the insurance company, Lordship.
OP2.
Yes, OP2.
Anybody
Lordship.
appearing?
Yes, he's appearing, Lordship.
You're for the insurance company.
But your Lordship, my argument is that the entire trial was taken place before the trial court. At the time of trial, yourself, the claimants file a claim petition, and the WS was also filed by the OP number 2, Lordship. In the entire record, it says that the person who died was operator, Lordship. In support to that, yourself, the claimants also exhibit one certificate, yourself. Mark as P exhibit number 5, yourself. Wherein it is clear that the person was an operator, yourself, because the vehicle question before this honorable court is an excavator, yourself. Is an excavator, yourself. But the learned court bailiff has made a manifest error while passing this impugn judgment award, Lordship. May I read the operative part, Lordship? Page number 27, Lordship.
Yes.
Paragraph 30. It says that now it is noted that in the referred judgment of Meena Varial Supra, Salendra Kumar Barua and others, and Bina Prasad Sonari Supra, there was no contract of premium for coverage of owner cum driver, and the insurance coverage was limited to third party. The foundation of fact and circumstances of the referred judgment are completely different from the case in hand on the following ground as under. Particularly the A refers A, Your Worship.
Yes.
Here the court below has, while referring the judgment, Your Worship, he said that one of the different in the refer judgment and the case in end is that all the refer judgment is personal private vehicle, and the vehicle of the present case is a commercial passenger vehicle, you see. But in my case, you know, it's not a commercial passenger vehicle. It's an excavator. Excavator, the Falkland, you see. In a simple sentence, we say it is Falkland. The vehicle which engaged for the construction of the road, you know, see. Not a commercial passenger vehicle. And the another is on para 31, you see. This is a very important aspect where the learned court below says made a manifest error without forcing the matter record placed before the court, you know, see. In the it says that in present case in hand, I have gone through the insurance copy, P Exhibit 7. On going through the P Exhibit 7 insurance copy, I found that there is a premium for third-party insurance coverage. However, no premium amount has been entered under head of the liability column for LL under WCA for carriers of more than 6 employees, excluding driver. and legal liability to person employed for operation and or maintenance or unloading except TP and OD premium. Answer to this, Your Lordship, may I take you to page number 58, Your Lordship. In the last page of my appeal, 58 in the first column, Your Lordship. It says the additional LL to person employed for operation
Which
and 58, Your Lordship. 58, the first column.
Yes.
In the first column,
50 lakhs.
yes, I have already paid the premium, Your Lordship. Now the learned code below is saying that
That there was no liability.
no liability was paid. But in the insurance copy, it is clear. Moreover, Your Lordship, the insurance policy is a package policy, Your Lordship. Package policy, which is a comprehensive policy, Your Lordship, in addition to liability only policy, Your Lordship. Even in the liability only policy, it's cover the liability risks of the.
You have given this.
Yes, Your Lordship.
What is this?
This is the.
Skilled operator.
Yes, this is a certificate exhibited before the learned code below by the claimant, Your Lordship. Whereas it is says.
Certificate is exhibited?
Yes, it is exhibited. Is in the record.
Given them?
No, Your Honor. Actually, it is filed by the claimant only. Exhibited by the claimant only. Is on the record, Your Honor. In the LCR, Your Honor.
Is it there?
We exhibit 5.
There? Okay.
It shows that the person died
Is
was a skill operator, not a driver, Your Honor.
So in that situation, if he's a skilled operator, how much?
Your
What,
Lordship,
what should have been given according to you?
skill operator, Lordship,
Not covered.
no, skill operator is covered, Your Honor. My content is that the skill operator is covered under the insurance policy.
So in that case,
The insurance company is liable.
is liable.
Yes, Lordship. I'm not liable, Your Lordship.
All
Because at the time of occurrence of the incidents, I have active policies. Duly, I have paid the entire premium.
The premium.
And yes, premium. And the active policy. And also, the insurance policy is a package policy, which is a comprehensive
Where
policy.
the insurance policy, you have annexed the policy here?
Yes, I have annexed a policy.
Where is it?
Page number, let's see, 54 years. Annexer 6 years.
Everything is covered.
Yes, Lordship. What the learned code below has come into the illogical conclusion that the driver is excluded. That's why the driver is excluded as per the policy.
But here he's not the driver.
He was not a driver. He was an
skilled
operator. He was a skill operator. And for such answer, the page number 58 is clear. I have already paid the premium.
Yes.
But unfortunately, I have been made liable for payment of the claim amount to the claimant, Your Lordship.
So this
Instead
amount is add LL to persons employed for operation.
Yes, employed for operation and or maintenance or loading and or unloading. Yes.
All right.
Employed for operation, meaning thereby the person who is employed for operating the machine, it's called a.
All right. And
yes.
Anything else?
No, that's why as per the facts and circumstances of the case, my sincere prayer before this honorable court is to quash and set aside the impugned judgment and order dated 4/6/2022 and remand back to the court below for issue fresh issues, Your Honor, for settlement of fresh issue, whether the as per available documents of the insurance policy, why the insurance company is not liable to pay you, Lordship.
Yes,
That's all.
My lord, if I may.
you are for the insurance company?
No, my lord, I'm on behalf of the claimant, respondent number one.
Yes.
My lord, my limited submission is that since they've only assailed this judgment on the basis that who is liable to pay, my prayer is that this honorable court will decide who is liable to pay.
You are interested in the money.
For a compensation, but
Doesn't make a difference who is making it, isn't it?
that is an issue.
Obviously.
But one submission that I would like to make, my lord, that is that this matter may not be remanded back. My lord, this matter was filed on September 2022.
All right.
Now is there. This honorable court may kindly decide.
This court can decide.
And whether who is liable to pay. Only that part is to be decided.
Yes, insurance company.
Yes, Lordship.
At page 58, it is covered. Skilled operator, exhibit 5. He's an operator. Why then?
Lordship, may. Lordship, then with regard to that, Lordship, I may have a lordship on page number 51 of the appeal. Page number 51, that is the insurance policy issued by the company.
Yes.
Yes.
Yes,
There is
51.
a schedule of the premium, Lordship, in the fourth box, Lordship, fourth column.
Yes.
Basic third party cover. TP cover, Your Lordship.
Basic OD cover, basic TP cover.
Yes.
Yes.
Yes, limited liability under WCA. That is for the third party, Lordship. Now the extra premium of ₹50 paid by them, Lordship, that is for the third party, Lordship. If any accident occurred to any other person beside the driver and the owner, Lordship, beside the driver and the owner, if any accident took place to any other person, that is covered, Lordship. If a third party claim is raised, however, Lordship, in the instant case, Lordship, this is not a third party claim, Lordship. The person operating the excavator, he himself was negligent. He himself got into the accident, and the deceased was the person who was operating the excavator, Lordship. And as Lordship knows that insurance policy, Lordship, has two broad sense. One is contractual and the other is the statutory, this policy. In that regard, Lordship, I may just place a...
These evidences, whether these points have been argued before the court below?
Yes, Lordship, that contention has been raised by the insurance company. Yes, Lordship.
Where paragraph?
Issue number 3, Lordship. Judgment.
So the person who lost his life was the claimant.
Claimant
The
son.
father of the
son.
claimant.
Yes,
So
claimant.
the father lost.
No. Son. No.
Son.
Yes, father has
And
claimed.
then the father filed the claim.
Yes.
And you are the
Owner of the vehicle.
owner of the
Vehicle.
excavating.
Excavating,
Lordship, the first thing involved here is that the person who, the deceased, Lordship, was not a third party. He was the person operating the vehicle. So in that case, Lordship, the third party claim that that they have paid the extra premium, Lordship, that cannot be put into.
No, but he is not the owner.
No, Lordship,
The person who
in
died.
that case, Lordship, I'll just
The
bring.
person who died
Yes.
is not the owner.
Lordship, I'll just.
What does the term third party mean?
Third party means the someone beside the owners and the driver, Lordship. Beside the owner and the driver.
So here third party is
Not involved.
not involved.
Not
And
involved.
according to you, this insurance is only third party related.
Yes, Lordship.
From
That-
where are you showing that?
Lordship,
Page 51.
page 51.
Which part?
Limited liabilities. That is in the first, second, third, fourth Lordship column. Schedule of the premium. All damage claim. The other liabilities. Basic third party coverage, Lordship. That premium has.
Where basic?
Basic OD cover.
Basic OD cover means what?
Own damage.
Own damage. And basic TP cover means?
Third party cover, Lordship.
So that premium is paid 1850?
Yes.
Yes, that is for the third party, Lordship. If any accident happens to.
And OD cover means?
OD own damage, Lordship. That is with regard to the vehicle. Vehicle, Lordship. If any damages is caused to the vehicle, then the repairing cost, Lordship.
And what
that
is
to be
this
paid.
added?
That is the IMT lordship.
Added LL limited liability to
Lordship,
person
I'll come-
employed for operating.
Yes,
That
lordship.
premium he has paid.
Yes.
Lordship, I'll come to that.
No, but he has paid,
Lordship may kindly have page
isn't
50
it?
Page 57, Lordship.
Yes,
Page 57.
yes.
This is the IMT, Lordship, issued by IRDA, Lordship. Here, Lordship, in the IMT 23, Lordship may kindly have PA, personal accident premium for paid driver, cleaner, conductors. That has not been paid.
So
Lordship,
that we are not concerned. In page 58, this has been tick marked.
Lordship.
This is add limited liability to persons employed for operation.
Correct.
Lordship, that is with regard to the third party. If any accident is caused,
No,
Lordship.
how do you say that? Because you see, basic OD cover, then basic TP cover, that you said limited WCA for carriage of more than so and so. That is third
Yes,
party. That
yes.
is done.
Yes, Lord.
Now, in addition to that, they have paid another premium, which is limited to operate the person who is employed for operating.
Lordship, these are added here, Lordship, in the 1,850 rupees, Lordship. This is the added premium, Lordship. These are the added premium, Lordship, with regard to the third party. However, Lordship, with regard to the personal accident premium for paid driver, there is not paid, Lordship. It has to, because the Lordship, the accident was of
Not
a personal
clear
accident.
to me. And from where from the judgment you can show this? In evidence, something was laid on your behalf to
Lordship, this
show that this is not third party.
Lordship, the learned trial court, Lordship, has discussed the same issues in issue number 2. There is a page
Please
number
read.
24, Lordship.
Yeah, you can read 24.
As regard to issue number 2, whether the OP number 1 and 2 is liable to pay compensation to the claimant or not. In this connection, the learned counsel for the insurance company submitted the claimant vehicle was insured only for third party, and the deceased being the driver of the vehicle is not entitled to get compensation. As such, the opposite party is not liable to pay compensation to the claimant. This was raised, Lordship.
So this is one limb of the argument.
Yes, Lordship.
The other limb of the argument of the other side is that the person who lost his life was employed as an operator, and to that Exhibit 5 has been introduced.
Yes.
Did you deny Exhibit 5?
Yes, Lordship.
You denied.
Yes. We have
So
denied.
where are those findings of the trial of the court?
Lordship, page number 29, para 34. May I read, Lordship?
Yes.
It is well known fact to every prudent man that the insurance policy has two broad categories. One is statutory liability policy and the other is contractual liability policy. Under the statutory liability policy, a vehicle is under compulsory to make insurance of vehicle before the vehicle is fly on the public road covering third-party insurance. And without taking such insurance policy is an offense under the Act. On the other hand, contractual liability is derived from contractual agreement in between the person taking the policy and the insurance company. It is purely an agreement to indemnify the person availing the insurance policy. It is not a statutory obligation imposed to insurance policy to provide such contractual liabilities under the law in all laws. CW1 law, para 35, has abundantly shown an exhibit document such and such, and to prove the accident occurred on such and such at such and such lordship. On spot when a big boulder rolled down from the hill or deceased, hence he is entitled to compensation either from OP number 2 as the deceased died during the course of employment. Had the OP number 2 availed the premium of legal liabilities to the driver, the liability would have been shifted to OP number 1. Without being so, the OP number 2 has taken the responsibility or the risk and thereby he is liable. Because lordship, the issue here was that a third party was not involved. Lordship. The first thing was that it was of a personal accident, lordship, of a driver. Lordship, operator and a driver, lordship. That can be, it will be of same, lordship, person, operator and the driver. They will be same, lordship.
How can it be same?
Lordship, because the operator is the
Do you
person.
have any authorities?
No, lordship.
Then get hold of some authorities on the point.
Lordship.
You can also give us. When can we have this matter again?
She would have been,
Hmm?
thought they could have it.
Yes.
The only point being
Very well. In that case, I can fix it on Wednesday,
On Thursday, Lordship.
Thursday.
Yes.
But you see, this code is only available till the next week. So Thursday, if we can complete, I can give the order. Otherwise, matter will I'll have to release the matter. Okay. So if you in that both parties can assess the code, you can also submit a short synopsis and whatever authorities you want to rely. Just give it because the point is very short. And also the ambit of 173, one decision on the power and ambit of this code under while exercising the appellate power under section 173, one decision on that, and whether skill operator is covered or not covered. That is the issue.
Yes, yes,
According
only
to him, he
yes.
has paid the premium, therefore he is covered. According to you, no, this premium is only in case of a third party accident. And here it is not a third party accident, here it is the driver.
Yes.
According to you. But he says it is not the driver, it's the operator. So to that extent, to what extent this court can go into that also. Right? List this matter again on Thursday, to enable the parties to submit written synopsis and authorities in the subject matter.
Deeply all right.
Anything else? All good? All right.